STJ Brazil-Japan Law Congress, the Evolution of Private Law, initiative that's promoted by the Supreme Federal Court with the support of Hitsubashi Invest, the Global Innovation, Education, and Research Center, the Japanese Embassy in Brazil, the Brazilian Magistrates Association, the Federal Judges Association, and the National Superior Perfection and Training of Magistrates in Brazil. We have in the opening table Their Excellencies Justice Antonio Herman Benjamin, Good morning. In the name of Justice Benjamin, I'd like to say how happy I am to open this table and this work on the opening of our second semester. So it's a joy to be able to start with such an important Congress. given the relations that we keep with Japan from both a commercial as well as legal point of view. It's the biggest community in Brazil. Well, the biggest Japanese community outside of Japan is in Brazil, and it's a great pride for us to be able to host this meeting. I'd like, therefore, uh, Chief Justice Benjamin, to congratulate you for this initiative and to say how proud we are to receive this whole community to discuss and debate subjects that are of common interest to us. I'd like to mention the presence of our National High Court colleagues, Justice Nancy, Justice Maria Teresa, Justice Humberto Martins, and a few colleagues that throughout the day will be participating in this meeting. Also, I'd like to greet here Chief Justice Erman Benjamin, Japan's ambassador to Brazil, Yasushi Noguchi, as well as the ambassador for Brazil in Japan, that is participating online, Otávio Henrique Cortes, Justice Lídia Maijima, that is the president of the Court of Paraná, the president of the Federal Judges Association, Elia Ferraz, Ambassador Felipe Drummond, Secretary of Financial and Economic Affairs of the Ministry of Foreign Affairs of Brazil, Professor Keisushi Takehita from the Tokyo University of the Law School of the University of Tokyo, and I extend my greetings to everyone else present here. At the end, I'd like to make some more comments about this legal connection between Brazil and Japan. But from the start, I would like to first of all hand over to Chief Justice Antonio Herman Benjamin. Chair, dear colleagues, I'd like to first of all, Justice Salomon, say how happy we are to participate in the opening of the second Congress of the STJ Brazil-Japan on the evolution of private law. Last year, we focused on public law. So first of all, I'd like to start greeting both ambassadors here, Ambassador Yasushi Noguchi, Ambassador Otávio Henrique Cortes, as well as Ambassador Felix Drummond. And I'd like to say that I feel particularly happy because Brazil and Japan are two countries that have quite a long cooperation tradition. And but until the National High Court actually took the initiative to have a law congress bringing specialists from both countries was something that had never been done as far as my research could tell, at least not an event of this nature. So what we had and have had were, of course, bilateral events between two law faculties, between 2-3 Japanese professors that know 2-3 Brazilian professors. And here we have two of the precursors of this cooperation that I will mention later on. But we've never had a truly joint meeting, including specialists from all regions of Japan and Brazil. In the Brazilian case, We have at least 10 universities here that are present with us. I think it might be even more than 10. Well, involved, we have 15 participating, but that are present here, we have 11. It's also a moment to thank Your Excellency, Justice Lucy Salomon, my colleagues of the National High Court, Justice Nancy Rodrigues, Roberto Martins, Justice Maria Teresa, the former two have been also Chief Justice at the National High Court. She doesn't like it that I mention that. But the Dean of our STJ, Nancy Andring, she always complains when I say she's the Dean, but she is an admired Dean, a great lawyer, and legal professional that is admired in Brazil and internationally. And I would also like to thank you from the very start, dear colleagues. I'd like to thank Ambassador Yasushi Noguchi for his cooperation and for the joint work we've had. It is not easy to organize an event such as this. I'd like to thank Ambassador Tavio Henrique Cortes, our representative in Japan, for whom we have who is very dear to us and who is currently in Tokyo, and it's 10 o'clock at 10 p.m. in Japan right now, but he is here online with us with his firm engagement to help us on this journey on compared law between both countries. I'd like to also thank both associations, the Federal Magistrates Association. Dr. Nalia Ferraz is here with us. Dr. Caio Marim, who was the president of the Ajufe, so her predecessor. For those who are visiting us, Dr. Analia is the first woman to be the president of the Federal Judges Association of Brazil. I'd like to thank the Itamaraty's support. And in the name of Ambassador Phil Fox Drummond Gold, I'd like to, and that I believe everyone knows him, is the chief negotiator for Brazil for any complex international trade subjects that, as we know, are not few currently. And lastly, to Professor Keisuke Takeshita, and all professors from Japan. He has been a very intense collaborator, as well as Professor Oscar Villena, who is also here with us today. So, to close, allow me to send you some data on Brazil-Japan's cooperation. First of all, it's good to remember that this relationship we have is not recent. We've completed 130 years of diplomatic relations. It was one of the first countries to recognize Brazil, an independent Brazil. Furthermore, last year, the bilateral trade between both countries was of almost $11 billion, whereas Brazilian exports reached $5.48 billion. The imports hailing from Japan reached a total of 6 billion. So it is not just an intense trade, but a balanced trade between both countries. And this is very important because it shows the health of the commercial or trade relations between Brazil and Japan. On the other hand, Japan is included in the list of the 10 biggest foreign investors in Brazil, with a stock of $35 billion. Not reais, but dollars. The relationship is also highlighted by a great presence of Japanese descendants in Brazil, the biggest outside of Japan, with over 2 million people, something that's already been mentioned by the chair, Justice Felipe Salomão. And in Japan, we have the fifth biggest Brazilian community with over 200,000 people. In the legal sphere, Brazil has over 200 magistrates, both federal, state level, that are Japanese descendants. Here on the table, at the table, have our Justice Lídia Maejima and also Carlos Muta, former justice. And I would like to greet all Brazilian magistrates that are of Japanese origins. Just so you can have an idea of the size of Japanese descendants working in Brazilian law, São Paulo alone has 54 magistrates that are of Japanese descent. I could say furthermore that Japan on its own has 3,800 magistrates. So you can see the percentage of Japanese descendant magistrates here in our country. It's about 5%, about 4% of the whole size of the magistrates of Japan itself. So these are the numbers that justify that we undertake this second Congress, dear colleagues and peers, from whichever point of view, the trade point, the investment side of things, the historical side of things, the point of view of a harmonious composition between those who came from Japan decades or even centuries ago. And we are all Brazilian, and that truly makes our country greater. I'd like to mention lastly that we have Justice Raul Araújo here, that is will be the next director of our National Judicial Academy Brazil, that is part of the organizational chart of the National High Court. So with these brief words, I'd like to greet you all once more. I thank all those that helped us reach this point, and special thanks as well to the National High Court's team, and especially the now Ambassador Arnaldo Fernandes and Dr. Giovanna Carneiro. And thus I declare open this second Congress, and I hand you back the floor. Thank you very much, Chief Justice Benjamin. Now to continue here for the welcome, it's just another 5 minutes so that we can respect the schedule. But I will first allow myself jointly with Justice Benjamin to thank all those that participated in the organization of this meeting, Justice Arnaldo and the whole team of the International Department and the ceremonial of the National High Court, that with every single care, together with Chief Justice Benjamin, with his perfectionism, organized this meeting in Congress. And also we have the arrival of Justice Raul Araújo, who will be the next director of the National Judicial Academy of Brazil, and has also a participation in the second session. There's a section on private law, And by the way, 3 colleagues here are very important members of the second chamber, and together with Justice Maria Teresa, who was already President, Chief Justice of this court. So I'd like to mention that we have one of the biggest law practitioners in Brazil of the theory of access to justice, that is Kazu Watanabe, that is present here with us, and it's a pleasure to have him with us. Continuing with our work, we're gonna listen to the Japanese ambassador to Brazil, Yasuchi Noguchi. Thank you very much. Good morning, everyone. I will speak in English so that the Japanese participants may understand what I am saying.
Everyone, I would like to congratulate everyone on the holding of the second STJ Japan Brazil Law Congress here today at the conference hall of the National High Court of Brazil. I would also like to express my deep gratitude to Chief Justice Enfam Benjamin for his efforts in organizing this event, as well as to all the Japanese and Brazilian participants of the Congress. Following last year's inaugural event, I am confident that this Law Congress will further strengthen cooperation between our 2 countries in the area of public and private laws. This Law Congress is of great significance, especially as the judiciary faces the need for further transformation amid technological advancements and the fast-evolving rights of citizens. In a world where political, economic, and social ties between nations are becoming ever closer due to developments in IT technology and artificial intelligence, the nature of the rules is being widely debated. There is a growing need to address challenges, such as the theme of this Law Congress, the publicization of private law and privatization of public law. Through this Law Congress, I hope that leading researchers and professionals from Japan and Brazil discuss key legal challenges over time. I expect this Law Congress to yield fruitful outcomes. Relations between Japan and Brazil are further strengthened in both political and economic spheres. Following the Japan-Brazil leaders meeting in June of this year, the commencement of negotiations on the Japan-Mercosur Economic Partnership Agreement is also a critical step forward. As Chief Justice Benjamin mentioned, we have a very traditional, long-standing friendship between Japan and Brazil, and this negotiation of EPA, and this EPA will further strengthen our friendship, and we would like to facilitate the trade and investment between Japan and Brazil in order improving the business environment. And also we are very much interested in enhancing our cooperation in the field of critical minerals or stable food supply. The Law Congress is quite timely and will be highly meaningful opportunity for both nations. The Japanese Embassy will continue to promote further development of Japan-Brazil relations and the strengthening of cooperation. Thank you very much. Muito obrigado.
Agradeço ao embaixador Yasushi Noguchi por suas palavras incentivam ao nosso congresso, estamos na direção correta e agradecemos também o apoio da Embaixada do Japão. O embaixador Otávio Henrique Cortes, que é embaixador do Brasil no Japão e participa virtualmente, também gostaria de solicitar-lhe as boas-vindas ao nosso encontro, embaixador. Muito obrigado pela sua participação.
Boa noite, ministro Salomão, muito obrigado. Senhoras e senhores, bom dia. Gostaria de iniciar minhas palavras com os meus cumprimentos ao excelentíssimo senhor ministro Antônio Herman Benjamin, presidente do Supremo Tribunal de Justiça, a quem agradeço o convite e a oportunidade de, mais uma vez, abordar o relacionamento entre o Brasil e o Japão. Estendo meus cumprimentos aos demais ministros, juristas, embaixadores e professores com quem tenho a honra de compartilhar esta ocasião, bem como a todos os interessados no tema que hoje nos acompanha. O Japão é o parceiro mais tradicional do Brasil na Ásia e vivemos atualmente um momento particularmente favorável nas relações bilaterais. Em um cenário internacional marcado por transformações econômicas, geopolíticas, desafios tecnológicos, pressões sobre as cadeias globais de suprimentos e crescente necessidade de cooperação para o fortalecimento do multilateralismo, nossos dois países encontram amplas possibilidades de atuação conjunta. Essa aproximação não nasce apenas de interesses conjunturais. Ela se apoia em uma história construída ao longo de mais de um século por sociedades que aprenderam a se conhecer e a colaborar de maneira profunda. O Brasil é o lar de mais de 2,5 milhões de nipodescendentes, maior comunidade de descendentes de japoneses fora do Japão. Mais de 200 mil brasileiros vivem atualmente em território japonês, contribuindo para a sua economia e para o dinamismo de sua sociedade, como bem lembrado pelo presidente Benjamin. Esses vínculos humanos conferem à relação bilateral uma densidade rara nas relações internacionais. A influência recíproca entre brasileiros e japoneses pode ser percebida em diversos aspectos de nossa vida cotidiana. Ela está presente na agricultura, na culinária, nas artes marciais, nas artes visuais, na educação e na produção científica. Nos últimos anos, também se intensificaram os intercâmbios universitários, as parcerias de pesquisa e a cooperação em urbanismo e arquitetura, que tem impulsionado a criação de cidades inteligentes no Brasil. Foi nesse contexto de confiança acumulada que se realizou em março de 2025 a visita de Estado do senhor presidente da República ao Japão, a primeira visita de Estado recebida pelo governo japonês desde 2019. A visita representou não apenas uma celebração dos 130 anos de relações diplomáticas, comemorados no ano passado, mas, sobretudo, uma decisão política de projetar a parceria bilateral para uma nova etapa. O principal resultado desse encontro foi a adoção em Tóquio do Plano de Ação de Parceria Estratégica e Global Brasil-Japão. Mais do que um documento de intenções, o plano estabelece objetivos concretos e mecanismos de acompanhamento para o período de 2025 a 2030, abrangendo desde o diálogo político até temas econômicos, tecnológicos, ambientais, sociais, culturais e consulares. O documento tem como objetivo redinamizar a parceria estratégica e global estabelecida em 2014 e consolidada na visita presidencial. Considero especialmente importante que o plano de ação tenha sido construído com base em metas mutuamente acordadas. Isso confere maior efetividade à cooperação bilateral e aproxima nossas iniciativas de resultados tangíveis. Os diversos memorandos de entendimento assinados entre ministérios brasileiros e japoneses durante a visita já começam a produzir efeitos práticos, o que evidencia o renovado dinamismo do relacionamento entre os nossos dois países. O crescente estreitamento dos vínculos também se reflete na agenda consular. Nesse sentido, merece destaque a realização em Brasília, na semana passada, da 11ª edição do Foro Consular Brasil-Japão, enquanto permitiu revisar os principais temas de interesse para as comunidades brasileira e japonesa, incluindo a situação dos nacionais residentes em ambos os países, bem como o fortalecimento da cooperação consular e a promoção de intercâmbios entre nossas sociedades. A dimensão humana permanece no centro dessa parceria estratégica entre os nossos dois países. No campo econômico, a relação bilateral vive um momento particularmente promissor. Em junho, encontro realizado à margem do G7 em Evian, o presidente da República e a primeira-ministra do Japão, Sanae Takaichi, anunciaram o lançamento das negociações para um acordo de parceria econômica entre o Mercosul e o Japão, a qual o embaixador Noguchi acaba de mencionar, e que será detalhada pelo embaixador Philip, presente nesse encontro. Trata-se de passo significativo para aproximar ainda mais nossas economias e aprofundar a integração entre as duas regiões. Esperamos e trabalharemos para que essas
And the
negociações
relationship between the two nations. We hope that these negotiations move forward in a strong way, contemplating the interest of both parties. This agreement is beneficial for both nations, and we want to encourage new investment, strengthen the integration of the productive chains, and to create opportunities for companies and workers from both nations. Besides this, it's going to be essential to improve our relationship and to become a strategic relationship between Japan and Brazil. The resilience of our supply chains became core in the international agenda. In Brazil and Japan, they have converging interests on this topic. So the exploring of critical minerals and also investment for innovative industries can contribute for the prosperity, the economic prosperity of both countries with the creation of new protective industries. The new technologies, they are another promising axis of this partnership. The advance of AI and of other technologies require cooperation between the countries that can unite industrial capacity, strategic vision. Brazil and Japan, they can work in a coordinated manner as partnerships for the creation of technological solutions and also for the generation of high-level technologies. I would also like to emphasize the judicial cooperation. We signed a treaty in 2024 when it comes to penal cooperation, and this is being analyzed by the Brazilian National Congress. This step is very important to increase the cooperation between the two nations when it comes to criminal investigations. And we are going to share relevant documents for penal lawsuits. The dialogue between the judiciary branches of Brazil and Japan is also becoming deeper. A proof of that is this Congress. So judicial authorities have visited Japan, and this was conducted by Chief Justice Benjamin in Tokyo last year, and he visited the Federal Supreme Court also, Luis Roberto Barroso, and we also had representatives from the Justice Council. And this shows and proves the vitality of this agreement, and then we can start this legal partnership and make it even stronger. The partnership between Brazil and Japan is very, very strategic, and these countries are supporting multilateralism, human rights, and also legal topics in the international arena. They are convinced that the international challenges make this partnership even more relevant. Brazil and Japan should continue working via this agreement, having economic cooperation, sharing information, and strengthening the human bonds that has been built throughout many generations. With this, once again, thank you so much for the invitation to take part in this opening ceremony. And I'm sure that the work done there, they are going to be extremely beneficial to everybody. Arigatou gozaimasu. Thank you very much. Ambassador Otávio, thank you very much for multilateral perspective, which is very important for us about the relevance of the Congress that we are having now, its second edition. Justice Lydia Maidjima, the floor is yours. Thank you very much, Justice Salomão, Luiz Felipe Salomão. Good morning to all. On behalf of the Supreme Court of the State of Paraná, I would like to greet everybody who's here. And also, I would like to greet in a special way Chief Justice Antônio Herman Benjamin and, uh, and Justice Luiz Felipe Salomão, the future Chief Justice of the STJ, and Justice Lancy Andrighi, Raul Araújo, and Your Excellencies, Ambassador Yasushi Noguchi, Ambassador Octavio Henrique Cortes, Professor Keisuke Takeshita, and Mr. Hakase, and Dr. Federal Judge Ana Lia Ferraz, and the other authorities, both Brazilian and Japanese authorities who are here and honor us for being here. Last year, when we were having the first Congress, the three panels of the event, they helped us to build bridges between two different legal systems, but united by dialogue. We discussed human rights, climate change, AI, and today, 1 year after that, being present here for the second edition of this event is a great personal and institutional honor, because the Supreme Court of the State of Paraná has a very close relationship with Japan. Kasatomaru ship brought 671 Japanese immigrants that had only a few suitcases, only a few tools, and great hope to restart their life on the other side of the world. Many of these immigrants and the generations after that came in the future decades, they found in Paraná not only fertile soil to plant, but also a new home. Today, over 1 century ago, Paraná has one of the largest Nikkei community in Brazil. Londrina, Açaí, Maringá, and the capital, Curitiba, they are totally integrated to the Japanese last names that got integrated to the Paraná tradition, jointly with Polish immigrants, German immigrants, among many others. And the cultural mosaic is also a lesson in harmony. These families did not come here to substitute one culture for the other, but they came here to add value. And that's exactly what this Congress represents in the area of law. Not an imposition of a system on top of the other, but a respectful relationship, respecting the differences and to overcome the challenges that both nations has. And the main topic of this second edition is the evolution of private law. After all, we are living through times that the borders are becoming more and more broken, and we have globalized markets, and we have to protect the consumers, and production chains, they go across the world in only a few days. Japan and Brazil, they can teach one another about how we can balance legal certainty with innovation. Throughout the panels, the professors, the judges, and the lawyers from both countries, they are going to discuss these topics with a depth that I do not want to anticipate before the right time. My role here is more objective, is to refresh in our memories that beside each technical debate about the evolution of private law, at the same time, we need to strengthen our trust, the trust between our nations, as shown by the Kasatomaru ship at the end of the last century. They can go further and further so that we can meet one another and prosper. Almost concluding, I wish that these 2 days of Congress, they are going to be very as fruitful as last year. And each participant is going to go back home with new legal knowledge and also with the certainty that the partnership between Brazil and Japan is more and more sound and productive. And the second STJ Brazil-Japan Law Congress is going to be a firm step of the crossing that we started over 100 years ago, and we are proud to continue building. Thank you very much. Domo arigatou gozaimasu. Thank you, Justice, the Chief Justice of the Supreme Court of the State of Paraná, Justice Lídia Maidima. Now we have the Federal Judge Analia Ferraz, President of the Brazilian Association of Federal Judges in Brazil, Ajufe. Thank you, Justice. Ladies and gentlemen, good morning. I would like to greet all of you via Chief Justice Antonio Herman Benjamin and Justice Luiz Felipe Salomão, the future Chief Justice. It's a great joy for me to represent Ajufe at the opening ceremony of this event. There is a common characteristics in the legal systems of the world. None of these systems evolved alone. Law evolves whenever there is a dialogue, when different legal traditions meet, and when we place things into perspective. Brazil and Japan have histories, cultures, and their own legal framework, but they share the same commitment. What is that? To build responses that are going to be able to keep up with our societies that are ever evolving. The participation and the topic of this Congress is an answer to that. We are bringing people from two countries to reflect about private law, and we are going to discuss consumer law, private law, international trade, and also the future of the legal profession. For the Brazilian judiciary branch, taking part in this dialogue is a great privilege. We are facing concrete challenges, and we know that a good legal system is also part of how we learn and learn experiences from beyond our borders. The international cooperation not only strengthens the academic production, it also strengthens the judiciary system. That's why the Brazilian Association of Federal Judges is very proud to be part of this event that is encompassing scientists, professors, judges, justices. We want to strengthen the knowledge we have, and we want to continue improving the law. I wish to all of you a wonderful, wonderful Congress. Thank you very much. Thank you, President Analia. Now we have Ambassador Philip Drummond. He works at the Ministry of Foreign Affairs here in Brazil. Thank you very much, Chief Justice, and other authorities. I believe that the reason why this event is so important, the event we are attending now, is because we can contextualize everything in a scenario that is highly fragmented of the economic and trade relations that we're having in the world right now. So we're going through a moment right now that has and is facing many activities in the different trade scenarios, areas. We are having many negotiations. I believe this moment is very, very challenging and important. We have opened up new fronts with many Asian countries, even Japan. We concluded other important negotiations. The main example, I could say, is Mercosur and the European Union. But at the same time, we are facing a situation that is highly fragmented, and there is a paralysis of the international trade channels. So it's a paradox. At the same time that you have a situation that is causing many, many changes and fragmentation of the system as a whole, the countries, they have started negotiating between themselves in different areas and fronts. So this is the context of this negotiation. We're going to give you more details later this afternoon, Chief Justice. But it's important for us to contextualize this important Congress. And we're going to give our contribution so that we can find the best pathway so that we can intensify the relations between Brazil and Japan. Thank you very much. Ambassador, thank you very much. And the last person to speak during this opening ceremony, Professor Keisuke Takeshita. Thank you very much.
Honorable Justices, distinguished guests, esteemed professors, ladies and gentlemen, good morning. My name is Keisuke Takeshita. It's quite difficult to pronounce, maybe. Professor of Private International Law at Hitotsubashi University in Japan. It is my profound honor and privilege to be here as a speaker of welcoming remarks at this second Brazil-Japan Law Congress. I would like to extend my deepest gratitude to the organizers and important persons. However, as I only have 5 minutes, it is not possible for me to thank each of the important persons, person by person. And therefore, I would like to express my deepest gratitude to the Chief Justice, Antonio Herman Benjamin, for his leadership to realize this important conference. I would also like to thank all participants from both countries who made this valuable gathering possible. Since I will assume the role of Vice President of Hitotsubashi University for Global Engagement in this September, I would like to deliver opening remarks on behalf of my university, which is also a supporting institution of this event. Japan and Brazil share a unique and deeply cherished relationship. Separated by vast geography, our two nations are nonetheless bound by long-standing historical ties, mutual respect, and a shared commitment to democratic principles. To realize the rule of law, which is a fundamental legal principle shared by both countries, this Congress serves as an invaluable platform for us to share our wisdom, exchange innovative ideas, and learn from one another's experience. Hitotsubashi University, my university, has a liberal academic tradition, and its mission is to create intellectual and cultural property which will contribute to the building of free and peaceful political and economic societies in Japan and the world. In my view, the rule of law is the essential basis for free and peaceful societies. We firmly believe that the variable judicial dialogue at this Congress will contribute to improving the rule of law, not only in Japan and Brazil, but also in today's global society. As a professor from a leading Japanese university in this field, I would also like to participate in the discussion. And we truly hope for the success of this second Law Congress and for such variable judicial dialogue to continue in the future. As for the continuation of Brazil-Japan judicial dialogue, it seems to me that there will be an important ceremony in this Law Congress. That is the adoption of the foundation charter of the Brazil-Japan Law School Consortium. The consortium, consisting of universities and other institutions from both countries, will enable us to continue such judicial dialogue. In addition, I believe that the consortium will be able to contribute to the realization of the action plan of both governments, strategic and global partnership action plan Japan-Brazil from 2025 to 2030, in which academic and educational exchanges and inter-university cooperation are also highlighted. The Graduate School of Law of Hitotsubashi University will become the first Japanese law school to join this consortium, and it will be serving as the consortium's secretariat. we are ready to fulfill our responsibilities. In closing, I would like to reiterate my sincere hope that this judicial dialogue will serve as a firm stepping stone for ongoing collaboration between the legal communities of Japan and Brazil. May our discussions today be engaging, insightful, and inspiring. Now I conclude my remarks. Thank you. Muito obrigado.
Muito obrigado, professor.
Thank you very much, Professor. Concluding, Chief Justice Benjamin, a few points that we have in common between Japanese law and Brazilian law. First of them is our tradition based on civil law. Our Roman Germanic tradition that is the same one as Japanese one. And therefore, beyond that, the coincidence that both countries have undertaken a legal modernization without breaking with their traditions. Japan was living through an isolationist moment until the Meiji era, even called, and forgive if I pronounce it incorrectly or in a Brazilian way, the seppuku, which was an isolation previous to the modernization that came with the and Brazil has also gone through a modernization process with the Constitution of 88 and then with the Civil Code of 16. So as both the Brazilian Civil Code as well the Japanese one from 1898 have several common points, and what is even more extraordinary, and I think that in Japan and the rest of the world as well, we are discussing the update of civil rights with the impact with new technologies, as well as in Brazil, we have also a commission that was organized to do this update, a debate that is currently being undertaken in the Federal Senate. And another really important point that I saw we have in both legislations is that both are centered in the case of civil law, which is very modern nowadays, despite being codes that are from the end and the beginning of previous century, but how centered they are in human dignity. So much so that many subjects that we're going to debate, though they are from civil law, this question on the protection of the people, the consumer, of families, of good faith, of trust, they are all present. And also in both countries, we value legal certainty. Japan and Brazil recognize this vector as essential for economic development, legal certainty, as well as having a foreseeable position of the judiciary. Tradition and innovation, therefore, meet and cross in this program that was carefully prepared by Chief Herman Benjamin and the whole National High Court team. And if you'll allow me, Benjamin, there is another point of contact between them. The role of the University of Brazil and Japan's university, as well as the magistrate's role in the perfectioning the magistrates with the National Judicial Academies, working with research, with teaching, with legislative creation. So our connection is a connection that goes beyond these borders, beyond the legal borders, as has already been mentioned here. We have the social, economic, cultural aspects. The one country is in Latin America and the other in Eastern Asia. These interdependencies and interfaces are really curious. These democracies, that of Brazil and Japan, trust, therefore, to the Supreme Courts to assure coherence, foreseeability in the interpretation of infraconstitutional law. So I hope these 2 days be very useful in building and deepening and the creation of these straightening of our ties. And may we build bridges for the development of this tradition and innovation. Thank you very much, and I wish you all a great Congress. So I'll hand it over to Chief Justice Benjamin, so we may continue to the next panel. Now, thanking all those that have participated of this opening, especially Justice Salomão, and allow me to make a reference to Ambassador Otávio Henrique Cortes, not just for the time difference, but also for his support to everything that involves Brazil-Japan cooperation, as well as Ambassador Yasushi Noguchi. I'd like to invite immediately Justice Raul Araújo Filho, who is the next director of the National Judicial Academy of Brazil, Enfam, E-N-F-A-M, and in the order of the National High Court, he will later be the Chief Justice of the STJ as well. The STJ is not isn't extremely exciting, but that's great because we can foresee exactly when each colleague will be the chiefs of it. The succession order so we know the order, which is usually brings colleagues to the presidents or to be chief justices of the National High Court, the STJ. So we have as part of this panel professors Keisuke Takeshita, who is already sat at the table, Professor Scavigliena, who is the director of the School of Law of the Getúlio Vargas Foundation of São Paulo, and the AGV São Paulo. We will have the Brazilian correspondent to the Secretariat of the Consortium, and Professor Ana Paula Mota Costa, who is the director of the School of Law of the Federal University of Rio Grande do Sul. This is a panoramic panel where we will be receiving from these practitioners that we admire. So, well, they will be talking about a few points that will guide our debates on the following panels. Justice Raul Araújo Filho is from the state of Ceará, beautiful state of Ceará. His Excellency was justice at the Justice Court of Ceará, the Supreme Court of the state of Ceará. Brazil is a federation. It is important that our Japanese colleagues be aware of that. And it is part of the second chamber. The National High Court is divided in 3 great chambers. The first chamber is public law. The second is private law, where Justice Nancy Andrigues is part of the private law, as well as Justice Maria Teresa is for the public law. And we have the third chamber that is on penal law. Without further ado, I hand over to Justice Raul, thanking all for being present. I will also invite Professor Masato Ninomiya to take a seat together with Professor Kazuo Watanabe, who's also here. So Professor Masato can sit on either side. But please do take your seat here. And also, colleagues, the Japanese professors, if you'd like to sit on the first row, please do feel free to do so. Okay, Justice Raul. Good morning, all. I'd like to greet we greet you for the second Congress, Brazil-Japan in the STJ. In the name of Justice Eman Benjamin, also Justice Justice Salomão, who were all very dedicated to the organization of this Congress. I greet as well Justice Nancy Rodrigues, Maria Teresa, who I believe has just left, but all colleagues present here. And all magistrates present here, diplomats, professors, professionals of the other areas of law that are here with us, be them Brazilian and Japanese. And to the other participants of this panel, Keisuke Takeshita, Professor Vilhena, Professor Ana Costa. It's a pleasure to have you here. So the subject of our Congress is on the evolution of private law. Law in Japan is strongly inspired on the Western legal systems of Roman Germanic roots, especially private law in Japan has strong influence of the European continental systems, especially from the Germanic one with their civil code, the German trade one, as well as French. Of course, with the inherent adaptations to the Japanese culture and life, and so a broad dialogue between law in Japan and the Western law systems, including Brazilian law. In regards to the subject that we're treating at this Congress, the evolution of private law, we know that the main factor currently that is pushing this evolution, be it in both private or public law, is linked to technology, of the technological component, and especially nowadays, AI. In our current world, it is not possible to think or talk about technology without referencing directly Japan. That is one of the most, where we have the most advanced technologies present in their lives that are developed worldwide. And so in the Congress, we're studying the evolution of private law that is made by technological advancement. It is important that we listen the opinions that we will have from specialists. that we will have from Japan, and that is what we will have in this panel, where we will have as presenters Professor Keisuke Takeshita, that is the ex-director of the School of Law of the university, former school dean of Hitotsubashi University, Tokyo, Professor Oscar Vilhena, dean of the São Paulo Getúlio Vargas Foundation Law School, and Professor Ana Paula Mota Costa, the dean of the Federal University of Rio Grande do Sul Law School. Therefore, I have the pleasure of handing over the floor to Professor Keisuke Takeshita for his presentation.
Thank you very much. Again, me. Honorable Justices, distinguished guests, esteemed professors, and ladies and gentlemen. It is my profound honor and privilege to speak also in this session of opening addresses. Once again, I would like to express my sincere gratitude to the organizers of this event, in particular, needless to say, Chief Justice Benjamin, for his strong leadership in making this important congress a reality. The title of my speech today is Private Law and the Necessity of Establishing Coordinated Cooperative Legal Frameworks. The general subject of this law congress is, as introduced, the evolution of private law. From my perspective, certain convergence of public and private law, which relate to the panel one's topic, is one of the most crucial aspects in analyzing this evolution. In my speech, I would like to analyze such convergence from the perspective of private international law, which is my main study field. Especially, I will focus on international dispute resolution in the field of private law. Recently, we have witnessed interesting individual examples of the convergence of private and public and private law in this area. After introducing these topics, I will analyze the phenomena of convergences and argue for the necessity of coordinated cooperative legal frameworks. With that, I would like to move on to my main part of my speech. Yes. To begin, I would like to outline my understanding of the convergences of public and private law. Convergences of public and private consists of two main phenomena: sovereign intervention to private persons' legal relationship by regulatory laws, which relates to publicization of private law, and empowerment of private persons or private parties to enable them to do something that are usually dealt with by public authority, which relates to privatization of public law. Let us look at a comparing recent topic for each of these phenomena. The first topic is EU-China intellectual property dispute, which illustrates publicization of private law. Initially, this issue was an intellectual property law dispute between private parties, private companies. However, after Chinese courts began issuing anti-suit injunctions, the character of this dispute shifted dramatically. While Chinese courts issued anti-suit injunctions prohibiting proceedings in other countries, other jurisdictions, foreign courts, such as a German court, responded by issuing anti-suit injunctions, ordering parties to refrain from applying for the anti-suit injunctions in China. As a result, the question of which court should resolve the disputes between private individuals escalated into a confrontation between sovereign states, taking on the nature of a dispute between them. And finally, the EU requested the establishment of a panel under Article 6 of the WTO dispute settlement understanding. Although the panel itself concluded that European Union had not demonstrated the China's anti-suit injunction policy violated the TRIPS agreement. An arbitral tribunal was subsequently established under DSU Article 25, acting as a de facto appellate body. The arbitrators rendered an arbitral award concluding that Chinese anti-suit injunctions were inconsistent with the TRIPS agreement. Consequently, China announced its withdrawal of anti-suit injunction policy. Anti-suit injunctions prohibiting proceedings in non-Chinese courts can be viewed as a regulatory measure, though through which sovereign states intervene private parties' decisions to bring actions in courts of countries other than the issuing country. Intellectual property disputes of private companies involve national interest of sovereign states, and the sovereign states might take such regulatory measures and intervene dispute resolution between them. To me, this is a striking example of publicization of private law, sovereign intervention via the regulatory laws in private disputes. On the other hand, we see movements of privatization of public law in private dispute resolution. These days, there are global movements promoting alternative dispute resolution, ADR, which represents the empowerment of private persons. For instance, United Nations Convention on International Settlement Agreements resulting from mediation, that is, the Singapore Convention on Mediation was adopted on December the 20th, 2018, to facilitate the enforcement of settlement agreements resulting from mediation. In the field of alternative dispute resolution, arbitration has long reigned supreme as the king of dispute resolution methods, supported by the United Nations Convention on the Recognition and the Enforcement of Foreign Arbitral Hours, that is the 1958 New York Convention. With the entry into force of the Singapore Convention, the movement for ADR, momentum for ADR is expected to grow even stronger. Japan acceded to the Singapore Convention, and it entered into force for Japan on April the 1st, 2024. Also, Japan revised its Arbitration Act in order to adopt the 2006 Ancestral Model Law on International Commercial Arbitration. Through the empowerment of private parties or private persons, the role of sovereign state shifts from directly resolving disputes to playing a supportive role, enforcing arbitral hours and mediated settlement agreements. In this way, empowerment of private persons are being promoted today in the area of private dispute resolution. And where appropriate, such dispute resolution replaces judicial proceedings based on national sovereignty. Analyzing these two topics, it seems to me that sovereign's intervention to the selection of forum for the resolution of private dispute by regulatory injunction, privatization of the sovereign state's function to realize more appropriate resolution of private disputes, both factors are fundamentally changing the traditional roles of sovereign states and private persons in the private dispute resolution. Consequently, coordination and cooperation among national legal systems have become increasingly vital. Through the publicization of private law, conflicts of regulatory measures by sovereign states may arise and must be avoided. While it was truly fortunate that the WTO dispute resolution mechanism functioned effectively regarding the anti-suit injunction issue, it clearly demonstrated the absolute necessity of coordination between national judicial systems. Similarly, wait a moment. Here. Similarly, empowering private persons through ADR highlights the need for international cooperation between different state judicial systems. As for the Singapore Convention, in order to realize the equality among private parties, the convention needs a broader base of contracting states. If a Japanese company reaches a mediated settlement with a company from a non-contracting state, that agreement can be directly enforced against a Japanese company in Japan, but might not be directly enforced against the counterparty in its home state. This creates an imbalance. Between them that should be avoided, because equal treatment of private parties is a fundamental principle of private law. From a private international law perspective, we must address the challenges arising from the coexistence of sovereign states. Establishing coordinated cooperative legal frameworks is no longer just desirable, it is essential. Yeah, I am now working towards the realization of a coordinated cooperative legal framework through the jurisdiction project at the Hague Conference on Private International Law, HCCH. Jurisdiction project is a legislative project to make a binding instrument that is convention on parallel proceedings, related actions, and international judicial cooperation. I had the privilege of serving as the chair of both the experts group and working groups for this project. Based on my experience as the chair, it is extremely difficult to reach consensus on certain coordinated cooperative rules as for those issues, because acceptance of those rules could be regarded as certain restriction of sovereignty. Therefore, it should be true that the minimum might be the maximum. The establishment of minimum standards may be the realistic first step. However, it should also be highlighted that to establish the minimum standards which realize a coordinated cooperative legal framework, certain value and merits of joining the framework need to be clarified. Realization of rule of law could be such values, and it should be the basis of such coordinated cooperative legal frameworks. However, it seems necessary to explain more concrete and precise values or merits beyond the abstract explanation of appropriate realization of rule of law. In concluding, I would like to emphasize once again the importance of judicial dialogue among experts from different countries, such as the dialogue in this law congress. Such dialogue promotes comparative law studies if a state wishes to develop its legal systems with a spirit of constructive flexibility. It must learn from the difference of the rules of other countries, exploring the new possibilities of development. At the same time, such judicial dialogue directly contribute to building coordinated cooperative legal frameworks among different countries. Given the deep and historical ties between Brazil and Japan, coordination and cooperation in this field are deeply important. We should continue to advance our legal systems in this direction, grounded in our shared commitment to the realization of the rule of law. Thank you very much for your kind attention. Muito obrigado.
Agradeço, professor Keisuke.
Thank you, Professor Keisuke Takeshita, for your wonderful presentation, showing the need to develop mechanisms of international cooperation, jurisdiction to solve conflicts between courts that belong to different countries, different sovereign nations, and the creation of bodies that are capable of exercising a transnational jurisdiction based upon the signing from different countries of these conventions and courts that would work with mediation based upon the Convention of Singapore, creating an international legal framework. Right after that, I would like to pass the floor to Professor Oscar Villena. Sir, you have 14 minutes for your presentation. Just a reminder. Oh, you have a clicker, I believe, on the podium.
Bom dia a todas e a todos. Imenso prazer, um privilégio estar aqui com vocês nessa manhã de Brasil ensolarado. Eu queria, em primeiro lugar, dar boas-vindas aos meus colegas, às minhas colegas que cruzaram o mundo. É um privilégio poder recebê-las aqui no Brasil. Queria também agradecer imensamente o convite que me foi feito pelo ministro Herman Benjamin, e além de ser um global scholar de enorme influência na área climática, tem se demonstrado magistrado estadista, capaz de construção de pontes inimagináveis entre culturas jurídicas, entre instituições jurídicas, inclusive entre o universo acadêmico. Gostaria de saudar a todas e a todos aqui nesse recinto, nas pessoas da ministra Nancy Andrighi, da minha querida amiga ministra Maria Tereza de Assis Moura. Sempre uma honra, um privilégio poder falar com as senhoras presentes. Me dá sempre mais temor as pessoas que estão aqui. Ministro, agradeço mais uma vez a palavra. Eu vou muito rapidamente, não quero tomar muito tempo de vocês, passar para aquilo que me foi solicitado. Quero justificar esse esforço que o ministro Herman Benjamin tem dito, que muitos de nós temos participado, desde aqui, meus colegas Ana, Ronaldo, da Universidade de São Paulo, de tantas outras escolas, em construir pontes entre o universo acadêmico de países com os quais nós não dialogamos tão intensamente como deveríamos. E vejo isso, essa justificativa, como razoavelmente óbvia, mas, apesar disso, eu vou partilhar as minhas obviedades com vocês. Eu acho que, em determinados momentos, é importante nós reforçarmos e compreendermos a razão pela qual nós estamos juntos nesse momento. Em primeiro lugar, é evidente que o Brasil e o Japão têm imensas coisas em comum. são países que há mais de um século trocam pessoas. Nada mais importante do que a troca de pessoas. Nós temos uma comunidade robusta, participante da vida brasileira, de descendentes japoneses. Nós temos uma comunidade brasileira no Japão que tem atuado de maneira também relevante nas últimas décadas. Então, as trocas culturais, comerciais, econômicas e políticas são imensas. No entanto, esse imenso intercâmbio não se reflete no intercâmbio acadêmico com a mesma densidade, especificamente na área do direito. Acho que em outras áreas de conhecimento nós temos avançado, como nas áreas de engenharia, de tecnologia. Mas no direito, sem nenhuma ofensa, os colegas que aqui visitam, mas falam pelo Brasil, nós somos ainda um pouco paroquiais. E talvez nós estejamos aqui buscando romper essa paroquialidade, buscando um intercâmbio mais intenso. Mas por que um diálogo entre nações tão distintas? Em primeiro lugar, porque essas nações distintas têm desafios comuns. Cada vez mais esses desafios são comuns. Na área da tecnologia, na área climática, na área de direitos humanos, na área de paz, imensos são os desafios comuns. Mas os contrastes entre essas duas nações, o contraste pelo qual essas duas nações organizam as suas sociedades, também podem ser imensamente frutíferos para que nós possamos refletir sobre a melhor forma de nos organizarmos. Se o direito comparado no final do século XIX, no início do século XX, era sobretudo um instrumento de extensão do poder das economias centrais, um instrumento colonialista, no final do século XX, ele assume uma outra concepção. O direito comparado pode, sobretudo, ampliar as experiências normativas do nosso repertório normativo. Afinal, o direito não tem laboratórios onde nós possamos testar as nossas soluções. Nós experimentamos através do outro, através da
We
experiência.
experienced
Essa é a primeira razão que, mesmo nações distintas como o Brasil e o Japão, podem se beneficiar da forma como distintamente regulam questões que são do nosso interesse. Mais do que isso, o direito comparado hoje serve para que nós possamos desnaturalizar as opções que fazemos. Muitas vezes fazemos uma opção e seguimos com essa opção, ainda que ela não seja mais funcional. Mimetizar um outro país, mas a experiência do outro país pode servir para que nós encontremos um caminho distinto daquele que estamos naturalmente trilhando. Vivemos, não há dúvida, um momento extremamente desafiador. Esse momento, todos os motivos que aqui já foram dados,
this moment for all the reasons that have already been mentioned.
fazem com que o direito tenha múltiplas funções, mas
That have multiple functions, where I would like to concentrate just on two, however, that it be submitted to a rigorous stress test. First of all, law has a function of stabilizing expectations. This perhaps be its fundamental function. How to stabilize expectations? Through the establishment of contracts, of creating procedures and institutions responsible to apply law. This obviously in the context of dynamics. Law does not want a static society, it needs to stabilize dynamic society. But when this dynamic goes through a hurricane of what we're living through, like currently in several different levels, it then has to have another function, which is the function to habilitate, that allows that we create the social adaptation within certain procedures, in certain rituals, preserving the fundamentals that allow that we leave a transformation process without violating the fundamental principles. That without leaving behind what allows us to live as a civilization. This capacity of this resilience, of adaptation, without leaving behind which is most fundamental, which will guarantee our well-being. And perhaps this would be the second reason why we're here. How we can go through these quick transformations, maintaining that which seems to be fundamental for the well-being of our societies. And so all these transformations that we're living through, I don't think I need to go through them in detail, puts the rule of law in stress. It stresses it, the international law and such. We see day by day where that law and order funded on multilateralism and the rule-based international order is being questioned at several levels, on the trade and commerce that we never thought would take place so early and quickly, but also on public relations. With a crisis, environmental crisis, a peace crisis, we have 132 conflicts currently taking place in the world, armed conflicts. And one of the main pillars that came from the Second World War was the Humanitarian Convention, the most ratified convention of the whole history by 196 countries, has been object of all violations that you can imagine. So we see an international order based on the law or rule of law, or the dream of it, that is being destroyed. This is a flag of the kind of challenge we have, but also a trade order that comes from the Second World War that is starting to be questioned, and that alternatives to this start to be conceived. So in that case, we need to be the architects of our own perception on how this new world order should function. In second place, we have, in function of the erosion of the mechanisms themselves and our organizational capacity to organize the political representation and to articulate the different political interests that exist in society, we also see an ever greater crisis of the constitutional democracies. The polarization, radicalization has placed our institutions that seemed to be stable, that are now being questioned. The promises that were not respected, the frustrations that have increased and that have placed our systems, our democratic solution systems, to resolve conflicts that are being questioned. All of this can also be an object for reflection in a group that puts together two great countries that have democracy and construction dear to them. And lastly, I'm just going to remind you of just one more element, a disruptive element that we currently have, that are the technologies that are not just ubiquitously filling each level of our life, but have also huge impact on law. In two ways. Firstly, because it is up to us to propose what the regulations are for each of these levels where technologies become ubiquitous, such as we've dealt with the question of privacy, on democracy, on data protection, such as we've done with all of these. So there's a whole regulatory demand that is up to us, and we must reflect upon this. But there is also a huge challenge on how to operate this technology within the legal complex that is part of each of these elements on their daily basis. The magistrates will still decide, or will decide with an intense support of AI. Lawyers, will they maintain their complex and costly operations, or will they have AI supporting them? This is all fundamental so that we may reflect jointly. This huge challenge, or these huge challenges that are accumulating in this short amount of time that we're living through, are without doubt placing or putting forth essential questions to us from academia. What should we teach? This could be a trivial question. And that we've never truly had such an acute questioning as we have now since Bologna. We know exactly what we've had to teach in the School of Law. The evolution on the changes we have had to do have been slow, but the law schools, as they are structured currently, can they deal with the multiple challenges that are presenting to us, that are being presented to us? What must we teach more? Is it more analytical capacities? Is it more law fundamentals and less of an encyclopedic vision of the legal system in which we are inserted? Must we perfect our capacity to strengthen the skills, the psychological, societal skills that a lawyer has? What must we do and how must we research this? What must we research and how? What is the scope that is relevant for research in law nowadays? How to study dogma in a world we live? How can we not have parallels with automated sciences? All this complex of questions is at the center of our questioning. How should we teach? Not just what, but how? Should we teach as we always have in a dogmatic way based on legislation? Or should we concern with the solution of the big and complex problems that our society faces? Well, I could give you a much longer list of questions that we ought to ask ourselves and must answer, but I shan't do it in respect of yourselves and the time that I have here. But I would like to end highlighting that Chief Justice Herman Benjamin has been making this effort to join academic communities that are not necessarily communicating as intensely as they should. And this challenge to create yet another community has been put forth. And it is in name of this Professor Takeshita and I have had the pleasure talking about this week how it is that we could help. And our role is not to coordinate, but simply to be a secretariat, to try and join each of your efforts during this meeting here and of others that were not able to join us here in person, so that we may create a generous, vibrant, and robust academic community in the area of law between Japan and Brazil. Thank you very much. Thank you very much, Professor Oscar Vilhena, who has brought us a brilliant presentation emphasizing the need to improve a compared law environment, to join different institutions and experiences of successful legal practices and experiences, reinforcing possibilities for new adaptation with the necessary agility in a multilateral context present in the international order and in the advanced current technology. We will now have the participation of Professor Ana Paula Mota Costa. And I also greet Justice from the Supreme Court of the State of Paraná, Lídia Seito. Good morning, everyone. Since the event is requested and because of the online transmission, I'm going to do my self-description. I am an average height woman of brown hair, with brown hair, also brown eyes. I have a dark blue dress on. Well, I'd like to thank Chief Justice Herman Benjamin for the trust, for having remembered me and the Federal University of Rio Grande do Sul, and for calling us to be present here in this honorable Congress. I'd also like to greet our panelists.
Dos anos, teve tantos desafios regulatórios, tanto no direito privado tradicionalmente, como a gente ensina na faculdade de Direito, lida com a ideia de igualdade entre as partes, autonomia de vontade e a escolha das suas relações, regulação de suas relações, desde que não façam aquilo que a lei pede. Uma vez o direito público mediar especialmente entre o Estado e o cidadão, numa condição de hipossuficiente. Isso, tradicionalmente, ocorre nas áreas de direito penal, por exemplo, que o Estado punitivo tem uma força coercitiva muito maior do que nós todos os indivíduos. Nesse momento histórico, a necessidade de uma intersecção entre essas áreas, especialmente se pensarmos na perspectiva dos direitos humanos,
For human rights, international treaties, and the need of people protecting people and their
tema dos direitos das crianças e adolescentes, o tema do consumo, especialmente o consumo internacional, virtual, e do meio ambiente. No caso do adolescente, tanto o Brasil quanto estão vinculados à Convenção Internacional dos Direitos da Criança, que prevê a perspectiva da proteção integral das crianças. A direito da criança lida com a questão do direito tanto privado, do Estado e da sociedade, a garantia de direitos para o desenvolvimento das crianças. Que esse fundamento, ele trabalha com uma ideia diferente daquela liberdade
that I was mentioning, the traditional idea of freedom in private law, because for children, we must protect them and they must have progressive autonomy. Why am I saying that? Because one day, all of the children, all of us, we're going to reach a context that our will has to have freedom. But this process needs to be followed up by a progressive autonomy and the protection, more protection than freedom. Brazil has already regulated this topic. This happened recently, a national piece of law that is called Digital ECA, the Teenager and Children Statute. And we opened up new possibilities with that, with the private relations limited by public laws and regulations, the operation of the companies and their responsibility when it comes to the digital world, mainly the international companies, which are our big techs, not our big techs that belong to the world in Brazil and in Japan. And so this shares with us a huge challenge, which is to make liable those who created the algorithms that define the permanence of children and teenagers connected to the internet, to our social media, the limitation of the time they spend online, the content, the identification of users, protection of our children within this space in which we should create this autonomy that is part of the progressive autonomy space. There isn't a world any longer that isn't a virtual world in which our children are going to grow up in. The creation of the digital ECA is a novelty. It was enacted in March of this year. It has already been regulated by a decree. It requires regulatory agencies, the regulatory agencies that are going to observe and monitor the companies, because we need to take care of our children in the private world, in the private space, and we also can make these companies liable as per our public law when they break the laws that have already been created and the new ones, because the technological world advances way faster than the legal world. So our common challenge right now is to study ways to make these companies liable in the international market, on the internet, and also in the consumption that is done. When it comes to consumption, nothing is more global than consumption nowadays, and nothing is more global as well as the hypo-sufficiency. So when it comes to consumption, the same way that we can buy and sell online at an international level, products that are manufactured in Japan, in Brazil, in other nations, this is part of our trading market, trading and supply market, but we have hypo-sufficient people, the elderly, children, people who have no access to technology as a possible tool for them to use it autonomously, and we have many tools. So our job as legal experts, besides making the private relationship, trading relationship feasible, is to protect the sectors of our society that are not in the same condition in terms of autonomy, equality, due to many factors, generational factors, the lack of technology, social issues, inequalities, mainly when it comes to our country, Brazil, when it comes to access to these technologies. As regards the environment, we all know that environmental law is a law for this generation and for the future generations, maybe a law that has never been so challenged as now because of the climate change, a law that goes from a public space that must be protected, and we also have private interests, huge economic interest, production interest, the use of the land, the use of the soil, because now it's one of the main challenges of the world. And there is a forecasting that starting in 2050, if we continue using the soil on this scale, we're going to have a problem in producing food, the division of land, the division of food. If this is true, the regulation of the environment is part of the public law, but is directly related to private law. What do I mean by that? It means that the main challenge for this law Congress and for all of us is to work on the borders, on the intersections between the public law, the private law. We are living on a globalized world. We have the traditional international law. It's not the same international law, and the sovereign states and their regulation challenges. The borders between these nations, they are highly diverse, very different, and everything that we are defining in the world is going through other relations. So the main challenge for the law is to create another balance in a regulation of equity. Equity is the concept that talks about treating different people in a different way, protect those who are in a different condition. So when it comes to surveillance and monitoring, in the protection of our children and our elderly when they are consuming, it should be delegated to the private sector. However, when we're talking about the liability, the penal liability of the several levels that are part of these relations that I mentioned, this job is the job of the state, of the public power in its several dimensions. And the government, the state, needs to punish whenever necessary to ensure guarantees to our individuals, as we have in the public law field. Based upon all of that, and based upon what Professor Vilhena mentioned, our academic challenge, besides updating our researches, researching these topics and many others, trying to find solutions, exchange solutions that can be brought from Japan to Brazil, from Brazil to Japan, exchange experiences. Besides that, our challenge is training law students. The law schools nowadays, they last 5 years here in Brazil, and whenever a student passes the college entrance exam, as we're going to have new students on the 5th of August, we're going to have new classes, new students arriving, and they're getting to the law school for the first time. Something we can be sure of, 5 years from now, when they leave the law school, the world is going to be different. And the challenges we're going to face are also going to be different. How are we going to educate these students? How are we going to train them? And I believe this is the essential part of this law congress. How can we deal with the law, and how can we deal with the students or the law schools, and how can we teach our students? Because we're going to have a new world ahead of us. Thank you. That's it. Thank you very much. Thank you very much, Professor Ana Paula Mota Costa, for the outstanding presentation, emphasizing the legal regulation need when it comes to certain social matters, when it comes to our children, our teenagers, the environment, the perception that we have nowadays within an international scenario. It's marked by technological advances that require fast changes for us in this social area. And we know that Japan, as well as Brazil, beyond the regulation of their civil codes and commercial codes, they have specific pieces of legislation for children, teenagers, and consumption, the environment. We have prevalence of the special pieces of legislation than the general laws. So your presentation was very interesting. This panel was very interesting. We had wonderful presentations. Thank you so much for your attention from all of those who are present here. Thank you, Professor Keisuke Takeshita, Professor Oscar Vilhena, Professor Ana Paula Mota Costa, and I would like to be the moderator of the next panel, okay? Justice Maria Tereza de Assis Moura.
Mais uma vez, cumprimento a todos.
Once again, I would like to greet all of you, and I wish to all of you a wonderful day, to those who are Brazilian and those who have come from Japan. And I'm very, very happy and I'm very glad to be the moderator of this panel that is called the publicization of private law and the privatization of public law. That is going to count on the presence of Professor Masato Ninomiya and also Professor Hajime Akiyama and Professor Daniel Machado. So my job here today is to be the moderator of this panel, and I don't need to read the biographies. The biographies are extremely important, but the biographies have already been shared with all of you, so we can move on to the next part of this panel. First of all, I would like to say that we are about 30 minutes late, 25 minutes late, and my situation is a bit complicated because lunch has been set for 1 p.m. and if we continue with the time allotted to our panel, we would delay everybody's lunch. And they want to have access to a nice meal and have lunch. Justice Nancy, she is the dean of our court. She is the women's dean. And I would like to greet Professor Ana Lia. She is the head of the law school of the University of São Paulo. My boss, she was my boss when I was at the university. So, Professor Masato, I need to greet the head of the law school, right? And so, without further ado, they have just told us that this panel, everybody should have had 15 minutes, but if possible, if you can complete your presentation in 10 minutes, we are going to help the anxiety of our colleagues who are a little peckish. So I would like to pass the floor to Professor Masato Ninomiya, once again saying that we're not going to read the speakers' biographies, and we would like to pass the floor to him. And now we are on a panel. So if you would like to use the PowerPoint slides, please make yourselves at home and you can use them. You can stand anywhere you like, sir. Would you like to stand? Would you like to sit here? Okay, thank you very much. So I would like to pass the floor to Professor Masato right away.
Bom, eu vou falar em português para
I'm going to speak Portuguese, okay, to make things easier. If I start speaking English, my English is not perfect, so it's going to take me a while longer. So I'm going to use my 10 minutes to talk very briefly. First of all, thank you so much to the STJ. I would like to thank all of the authorities. Thank you very much for the invitation. I have been keeping up with the Decassegue movement for about 40 years now. Since the very beginning of this phenomenon, that was something unique when it comes to the immigration. I listed here our history between Brazil, Japan, our relationship, okay, based upon what was mentioned, 130 years of international relations, over 100 years when the immigrants arrived, the war, the San Francisco Peace Treaty, 190,000 Japanese who came before the war, and 60,000 more that came after the war, even my family. My family is included in that, and according to calculations from the Ministry of Foreign Affairs of Japan, we have 2.7 million Nikkeis in Brazil, from the first to the sixth generations, and about 210,000 Brazilians living in Japan at the moment. And now, how can I change the slides, please? Oh, here. What happens? Why do the Japanese that came with so much hope to Brazil ended up going back to Japan? When we came to Brazil in 1954, Japan was a very, very poor country, and Brazil was way richer. But Japan has advanced, Brazil as well, but there was a huge economic boom in Japan that forced or invited the Japanese and their descendants to go back and work in Japan. And many people, because of this crisis that you can see on the slide, the Collor Plan and many other things, the Brazilians who love their country, they ended up going to other countries. So many of them went to Japan, many of them went to the USA, to Europe. The Japanese immigration law always made it difficult for foreigners to go to Japan and work there. But in order to meet the labor market in Japan, they remembered that immigrants who came not only to Brazil, but to Latin American countries in general, Peru, Paraguay, Bolivia, Argentina, and even the Dominican Republic.
So, to facilitate the entrance of Japanese descendants, they made a change in the immigration law to allow second and third generations to enter more easily in Japan. And at the time we asked, what about the fourth and fifth generation? We're saying Nisei, Sansei, I don't know, não sei in Portuguese, I don't know. So but they cut it at the Sansei. And well, we then have problems later, but that's another story. Well, the Brazilian legislation itself, no one remembers this, of the Penal Code of 1940 said that it was a crime to enlist Brazilians to leave the country. We had to change this law. Congressman Moura headed this movement and made a change and said it would be a crime only if there was a fraud involved. So things cooled down, and they also had the Mendes Jr. law that gave all privileges for Brazilians that would work in Iraq in order to work for construction of railways. But that didn't include the Japanese companies because they couldn't get the same privileges that the Iraqis were giving. Now, the arrival of the Japanese descendants back to Brazil was a true tsunami. As soon as the law was changed in the 1990s, more than 40,000 Brazilian descendants of Japanese went to Japan. In the next year, 84,000 people, especially from São Paulo, over 60,000 visas were given in the consulate of São Paulo, to the point where the staff in the consulate not being enough. Since then, about 10,000 went to Japan, but they saw several difficulties. There were bad faith people enlisting them there. These were just a part of the issues. The adaptation of Brazilians in Japan was also very difficult. It was the mistakes of the Japanese authorities thinking that Niseis and Sanseis would more easily adapt to Japan. They thought the Niseis and Sanseis already had Japanese language and culture within them, but that did not happen. Niseis perhaps, but the Sanseis had more difficulties because parents maybe already only spoke Portuguese at home and so on. And the Japanese system was also not prepared to receive such a huge amount of foreigners. I often say that nowadays Japan has 4 million foreigners living there, almost 1 million Chinese, 800,000 Vietnamese, 400,000 Koreans for other reasons, 300,000 Filipinos. Brazil was in 5th place, but is now has even less than Myanmar, Nepal, etc. And all of them were facing difficulties, and Brazilians were the pioneers to try and change the system of the Japanese government a bit, with social security, labor laws. So the 20th century, the last 2 decades of the 1900s were really problematic in that sense. Child's education. I arrived in Brazil with 5 years old, 7 years old. I got into school without understanding a single word of Portuguese, but I managed to adapt. The same thing happened in Japan. But the children of 6 to 7 years are more easily adaptable. Now, when they're a bit older, 9, 10 or on, and the Japanese system obliges them, they enter on the 3rd or 4th grade immediately without even speaking the language. It was much more difficult. Without mentioning bullying, of course. Children can be cruel. The Japanese colleagues would not accept the child that, although they looked physically the same, but they did not speak the language. And so we created the SIATs, the Center for Information Support for Workers Abroad, to try and help the Brazilians who are going to Japan. Japanese language, legislation, social and cultural norms, etc., etc. And the Embassy of Japan sent a verbal note, a note verbal, to the Itamaraty, and we are entity recognized both by the Japanese and Brazilian government to give the support to the Brazilians that went to work there. So a great crisis, financial crisis 2008. Well, we have about 320,000 Brazilians in Japan, but that number decreased drastically, half as much, because the Japanese government gave help for Brazilians to be able to come back to Brazil. A smart measure, but it was a way of Brazil to get rid, so to speak, of the amount of Brazilians that were in Japan. And so now we have about 310,000 nowadays again. So this is the data that I've mentioned, a huge concentration of Brazilians in the north of Tokyo, and the region of Aichi, Shizuoka, and that's about the amount of foreigners in Japan.
segunda geração, Niseis estão
And the
envelhecendo.
second generation, the Niseis, are now mostly older, those who are working at the third generation. And so we tried to take a flag to take the Yonseis. But many difficulties were created. And although from 2019 up to nowadays there'd be a quota of 4,000 Yonseis per year, so there should be over 30,000 Yonseis, not just from Brazil, from other areas as well, other countries. But due to the legislative difficulties, only 250 Brazilians or descendants of fourth generation entered Japan. Such is the difficulty. So this is a picture of the Brazilians that are working there. Then we have the question I mentioned of the difficulties to adapt. And there are several issues: crime, social security, traffic accidents, everything you can possibly imagine in a community of 210,000 nowadays. But the current government, up to the previous government, there was a lot of wish to flexibilize the presence of foreign people in Japan. But the current government tends to be more restrictive. They want to make the presence of foreigners more disciplined, so to speak. This is the word they use, because there were a lot of crimes from Brazilians and Latin Americans before. Now it's a lot of crimes from Chinese. So they want to be more disciplined in that sense. So now we also have some changes. Recently, on the 24th of July, 29th of July, had two decrees. One is to increase the visa exemption. Since the Bolsonaro government, there was a suspension of the demands for visa. And now it's been increased for another 3 years. And this novelty here is called the working holiday. This is the great novelty, because the 18 to 30-year-old youth can be in Japan for up to a year to get to know the country and the possibility of working at the same time. And it's not just for Japanese descendants. All Brazilians can go to Japan and remain a year, know the country while working. That is the great novelty that has been discussed for a long time. The military governments didn't want that, and now finally we've had this, which is very welcome, because many Brazilian youth will be able to get to know the country. So this is just a quick overview. Apologies for taking too long. But what I wanted to show is the importance of the human connection in multilateral relations. To see and know the presence of Japanese immigrants, dissidents, and then Brazilians. And so we have Dr. Kazuo Watanabe here, that was the first descendant to become a magistrate, a judge in Brazil. Now, Justice Benjamin talked about the number of magistrates we have that are of Japanese descent. Now we have even in the armed forces, generals and officials. So this integration that throughout these 10 years was very problematic, but nowadays we are completely integrated. And we will now have the Brazilians in Japan that are changing the Japanese mentality on this immigration. Thank you very much.
Agradeço, professor Massato.
Thank you, Professor Masato. I don't know in regards to the professors, but the amount of Japanese descendants in the University of São Paulo, but Professor Kazuo Watanabe, that was the first magistrate. He was my professor in the second year of law school. Very proud to have been his student on general procedural theory. Professor Cândido and Professor Kazuo Watanabe. I know that his contribution as well is a great addition to the university and makes the participation of the descendants of Japanese in Brazil very important, as well as many other magistrates. And I'd like to highlight here and thank Professor Masato for all your contribution for the SIACE, because it's an institute that allows Brazilians that wish to go to Japan, that gives them a great ease for their immigration and guidance of all that wish to migrate to Brazil now, and with the fourth generation, the Yonsei, and this incentive so that this may happen. Thank you very much, Professor Masato. We must recognize the importance of your participation for this relationship between Brazil and Japan in the academic area. I'll hand over now then the word to Professor Jimmy Akiyama of the University of Tsukuba for your participation.
Boa tarde a todos.
Good afternoon, everyone. I don't speak Portuguese very well, so I will speak and make my presentation in English. Thank you very much.
Good afternoon, everyone. I'm Hajime Akiyama, an assistant professor of the Institute of Humanities and Social Sciences at the University of Tsukuba. Tsukuba is in Ibaraki Prefecture, and it is located around 17 kilometers northeast of Tokyo. It is my honor to present in this Congress this year as well as last year. Last year, some of my students participated in this Congress on site. This year, unfortunately, I could not come with my students, but some students should be watching this Congress online. I deeply appreciate the warm hospitality of the STJ, both last year and this year. I arrived in Brasília around midnight today, and I have already been warmly welcomed. I also wish to appreciate translators. The University of Tsukuba served as a co-organizer of Japan-Brazil University Rectors Summit in 2025, and I believe that we will continue our ties to Brazil. Our university will launch a new interdisciplinary legal graduate program called Masters and Doctoral Programs in Innovative Legal Studies in April 2027. The vision of this program is to innovate law by interdisciplinary perspective, and I believe that this is somewhat related to statement of Professor Oscar Verhena just previously. Some speakers have mentioned the role of law in technological advancement, and science, technology, and legal systems will be one of the fields in our program. Students can study either in English or Japanese. Of course, we will welcome Brazilian students as well. So please talk to me if you or your students may be interested in our program. This year, I would like to make a presentation titled, Is Nationality Public or Private? Rethinking the Legal Nature of Nationality. It is my honor to make this presentation, and I am also a little anxious because I present right after Professor Masato Ninomiya, who is a specialist in nationality law. After I introduce myself, I will talk about understanding of a nationality in international and Japanese law, and discuss the two dimensions of nationality from the perspectives of public and private law. At the end, I hope to rethink the legal nature of nationality, and I try to refer to Brazilian understanding of nationality. So let me introduce myself first. I identify myself as a scholar of peace studies, and I have some disciplines, including Japanese constitutional law and international law. My research focuses on nationality and statelessness. I completed my PhD in 2020 with a dissertation titled The Law of Preventing Statelessness in International Law and Its Influence on Japanese Law. The research question of today's presentation is, what is the legal nature of nationality? I have traditional division of public law and private law in mind in this research question. Okay, what is nationality in international law? According to a well-known Nottebohm case by International Court of Justice, ICJ, in 1955, nationality is a legal bond having as its basis a social fact of attachment. Although the state is not written here, this wording and the context indicate that nationality is a legal bond between a state and individuals. How about the Japanese law's understanding of nationality? The Supreme Court says that, quote, Japanese nationality is not only a qualification for membership in the Japanese state, but also an important legal status, unquote, and lists some examples of a legal status. I hope to emphasize that there are two different concepts here. One is membership and the other is a legal status. Here's one interesting comparison with the understanding of nationality according to international law and Japanese law. ICJ says nationality is a membership and ICJ says nationality is a legal bond, whereas the Japanese code says nationality is a membership and legal status. The relationship between them is not necessarily clear, but I interpreted that a legal bond is similar to membership, and legal status may not be necessarily included by international law. One reason I interpret this way is that contents of nationality depends on a state, so that international law does not seem to cover whether nationality is a legal status or not. I also wish to introduce the method of acquisition of nationality in Japan. In Japan, jus sanguinis is basically applied. Jus sanguinis means that you acquire nationality if either of your parents is Japanese. Although the Japanese nationality could be passed by only fathers, when Professor Ninomiya published this book on equality of men and women in nationality in 1983, since 1985, both fathers and mothers can pass their Japanese nationality. In either case, parentage is crucial for acquiring Japanese nationality. I'm thinking about the possibility that jus sanguinis and the understanding of nationality to refer to both membership and legal status may be relevant. In Brazil, jus soli is in principle, so that you acquire nationality if you are born in Brazil, although jus sanguinis is also partly applied. I'm thinking about the possibility that the understanding of nationality can be different based on which principle to apply. Now, I would like to move on to the analysis of nationality from both public law and private law's perspective. If we view nationality from a public law perspective, there are some characteristics such as membership in a political community, rights and duties toward the state, voting rights, etc. This feature is because nationality is primarily understood as a public law status, and the relationship between individuals and the state is important. This may be like international law's understanding. If you see nationality has a feature of private law, the feature looks a bit different. We can observe that nationality also influences family relations, parent-child relationship, marriage, inheritance, and private international law. As a result, nationality can be understood as a personal status. This sounds similar to the Japanese law's understanding. I particularly wish to emphasize that family relations and parent-child relationship are relevant. Japan applies jus sanguinis, and as a result, nationality is directly linked to family relations and parent-child relationship. Thus, here's one hypothesis that a nationality's feature of private law may be stronger in a state which applies jus sanguinis. Let's rethink the legal nature of nationality now, and this will be the answer to the research question of this presentation. The research question was, what is the legal nature of nationality? By looking at these different understandings, the answer to this research question is nationality should be understood as a hybrid legal institution located at the intersection of public law and private law. Nationality has a public dimension, such as political membership. It also has a private dimension, such as personal legal status. However, as I discussed in the context of Japanese law, jus sanguinis may strengthen the private law dimension of nationality. I wish to end this presentation by referring to Brazilian understanding. I was wondering about the Brazilian understanding of nationality, so I searched about it. As far as I was able to determine, I could not come up with a judicial definition, which means the court's definition of a nationality. However, I found one understanding according to the Brazilian constitutional legal scholar. This scholar says, quote, nationality is a legal political bond between an individual and a state. Through this bond, the individual becomes a member of a state and acquires, the individual becomes a member of the people constituting the state and acquires rights and duties within the constitutional order, unquote. By the way, this was written originally in Portuguese, but with the assistance of the AI, I could read it in English. I hope to point out that a similar understanding was used in Professor Ninomiya's book in Japanese, which I just referred to. Interestingly, this sounds like the Japanese really similar to the Japanese understanding. I thought that the feature of nationality can be different, depends on how nationality was conferred, but I'm not too sure whether this is the case when I looked at the Brazilian understanding, actually. It may be interesting to compare the role of nationality in Japan and Brazil, which use different way to confer a nationality. The slide was not available for a moment. I know the reason, because 10 minutes has passed. So that maybe the organizer just forced me to stop this presentation. Okay, so this is the final slide, don't worry. All right, I hope this presentation indicates that nationality is an intersection of these two areas. Thank you very much for your attention. Obrigado. Arigatou gozaimashita.
Muito obrigado, professora Jimmy.
Thank you very much, Professor, for your comments and your presentation. It would be wonderful for us to listen to Professor Masato when it comes to the topic of nationality. Unfortunately, we have a limited amount of time, but then maybe later we can open up for a Q&A session. Your vision about the context of what nationality truly is, the intersection between public and private law. And we could also listen to Professor Nancy, that is an expert in private law, and I'm sure she would be able to contribute a lot. And Chief Justice Herman Benjamin, who is back into the room. I had not seen you, Your Excellency, and very interesting your presentation on nationality, private law, national law, the criteria that we should adopt so that we can acknowledge a person's nationality, jus solis or jus sanguinis. Very interesting. Thank you so much for your presentation. Now we would immediately like to pass the floor to Professor Daniel Machado. Even though he is Brazilian, he is a professor at the Gakushuin University Law School in Tokyo. I had a class with Professor Masato, but I don't know if I pronounced the name correctly, and I would like to pass the floor to you. Good morning, ladies and gentlemen. First of all, thank you so much, STJ, and also the Embassy of Japan for organizing this event. My name is Daniel Machado. I'm a professor at the Gakushuin University in Tokyo, and I'm going to talk about the constitutionalization of the civil law in Japan. So I would like to introduce myself. I got my degrees in Japan. I have never studied law in Brazil, so I haven't spoken Portuguese for quite some time, so please bear with me. It's a bit difficult for me to speak Portuguese now, and currently I am a professor of civil law at the Gakushuin University in Tokyo. I study mostly and I research mostly family law, liability, civil matters, globalization of the legal education, and I also teach civil law in Japanese, and I also teach civil Japanese law in English, such as the Nagoya University and other universities. And starting this year, I'm going to start teaching at Tohoku University. The photos here on the slide, they are photos of the Gakushuin University campus, where I am a professor, and it is the university that the imperial children go to. Starting my presentation now, a good starting point for us to discuss the constitutionalization of the Japanese civil law is the 1947 Constitution. In Japan, the proximity of our Constitution and civil law started with this Constitution, the Constitution that we have in effect now, that was enacted after World War II. The new constitutional principles of individual dignity and equality among the genders, they created a great reform. They implemented a great reform in our civil code, and we needed to amend books 4 and 5 that set forth the family laws, and it's based upon the new constitutional paradigm. Since they didn't have time to reform the civil code before the new constitution was enacted, we created a law of provisional measures to talk about how the new civil code laws should be applied, that would become constitutional, and how they should be applied up until the reform was carried out completely. This law is formed by 10 main articles that set forth the main characteristics of the amendments made in 1947. Abolishment of the married women, the patriarchal families, the parents didn't need to consent the marriage of older children, and also the abolishment of the heritage law when it comes to the civil code based upon the patriarchal family. And this was shared in life or after death jointly with the assets that was shared with the firstborn. Besides the amendment of books 4 and 5 of the Japanese Civil Code, at this moment we introduced articles 1 and 2. The first one is more explicit. It talks about the need of interpreting the code based upon the first article that is less explicit talks about the individual rights, the good faith, and the prohibition of the abuse of people's rights. So general rules that allow constitutional values to enter this. It's important to mention that with the 1947 Constitution, that Japan allowed the constitutional control, adopting it for obvious historic matters, adapting it to the North American Constitution. Different from what happens in the U.S. law, it doesn't apply in the Japanese law. However, as a fact principle, the constitutional has a binding effect similar to other countries. Another common characteristic, so the self-contention when it comes to the constitutional control. As you can see on the slides, it's possible to add to a single slide all of the constitutional norms that were declared unconstitutional. So about 1/5 of the unconstitutional decisions, the Supreme Court issued 3 unconstitutional declarations regarding family law. One was the decision mentioned by Professor Akiyama in his presentation in 2008. The court declared the nationality law that said that it was unconstitutional for the children of a foreign mother and a Japanese father not to become a Japanese. And it should be the children that were called legitimate. Finally, in 2015, the court declared the partial inconstitution of the article for the women to wait for 6 months to get married again because of the paternity of the previous marriage with the next marriage. So these sentences in a short period of time could maybe talk about a change in position of the court, the Constitutional Court. But on the same day, on the 16th of December of 2015, based upon this last sentence, the court said that Article 150 of the Civil Code that forces the men and the women to adopt the same last name after they got married, showing that this constitution inconstitutional and so this is the constitutional control, because the court stopped itself from interfering in a matter that in Brazil is that in Japan is considered to be socially sensitive. On the other hand, there is a greater constitutionalization of and they are trying to attract attention to the society. And sometimes the society does not move when it comes to sensitive matters, marriage between people of the same sex, and also to change the last name because of a marriage. And even there is this self-contention, it doesn't mean that the Japanese judiciary is not going to consider the sentences from the infra-constitutional officers. You can see some examples of infra-constitutional activism when it comes to family law. They are not limited to this slide. And one example that is easy to understand based upon the Brazilian law would be example number 2. In 1958, the Japanese Supreme Court, when it comes to the matrimonial law, decided to set forth the stable union. It was legalized. Another example that is more recent, I'm going to only share 2 examples because my time is almost up. Example 5 talks about the sentence that the Supreme Court, and so the union or the marriage between people of the same sex, and it's caused also a great impact. And the Supreme Court in Japan did not support itself on any constitutional law for this decision. When there is an infra-constitutional intervention, with translation apologizes, he's speaking too fast. And the lawmakers, they can legislate any way they find that they should. An example of the Supreme Court in Japan was a sentence of 2023 of the inconstitutionality that talked about gender change surgery. And they considered illegal the administrative. So the Ministry of the Economy had a transgender woman who wanted to use the women's restroom, and she was forbidden to do so. And the advance of reaction when it comes to transgender people. And so conservative lawmakers, they got together and they considered that this kind of movement would risk the safety of the women in Japan. And so the other requisite that sets forth the need of a gender change or sex change. However, different from what usually happens when the court declares something unconstitutional, some people are refusing to ratify this, and the result is that due to this inertia,
quanto no âmbito infraconstitucional, no infraconstitucional, reinterpretando que esse requisito
in this requirement that is remaining, so they can undergo the sex change surgery. Even though this is protecting people's rights, there is a conflict among the branches, and this causes a lot of problems for the people involved and for our society. We still have many things to say, but since my time ended 2 minutes ago, I'm going to wrap up by saying the need to revalue the infraconstitutional officers to avoid conflicts among the branches. As J. Mark said, he deals with compared law in the US and Japan. As he mentioned in his book, The Second Best Justice, maybe the search for the ideal justice is something that is going to get us closer to an ideal justice. An imperfect justice can be more effective than insisting on trying to find the ideal justice. Thank you very much.
Agradeço ao professor Daniel
I
Machado.
thank Professor Daniel Machado.
A sua fala foi muito
Your presentation was really interesting to bring the information for us in regards to things connected to the constitutionalization of family rights or law. But the presentation was really good, but very fast. We wish it could be, we could have had another 15 minutes so we can learn even more on this very interesting question that was brought forth by you on the limits, the advances, and the difficulties on this regulation. And for us Brazilians, there's also some connections that are really important. And it reminded me, it's not from your time, you're still very young, but when I was a child, I remember that only with the married woman statute in 82 did we see dispensed from the obligation of having a husband's authorization for many things, including the status of semi-incapable or invalids. Not so long ago, actually. And these advances that took place in Japanese society, including about stable unions and such, is part of our debates on the law for divorce, which is very recent in regards to history as a whole. We could be here discussing this and bringing other examples and your experience as a professor, but I did not understand very well if you understand that you have difficulty in speaking Portuguese or understanding, because you spoke extremely quickly and very well, perfectly. So I'm not sure what you meant with that, but we have perhaps a few minutes before lunch. Since everything was so fast and intense, I'd like to know if someone would like to know in 5 minutes if they would like to ask anything to our dear panelists on what was presented. Justice Nancy? Yes, I would just request that you please present yourself, introduce yourself. Good morning, I'm Floriano, researcher and journalist, researcher in Asian studies. I'm going back to Japan soon, so I'd like to congratulate you for this presentation. And as you said, was very interesting. But in regards to the previous presentation, of Professor Oscar, with whom I've identified a lot, and also thanking you for that. He used two expressions that were really interesting. Turbulence and parochial manners. This is how I'm seeing a true turbulence hurricane, a society being reached by a series of questions that go all the way from the President of the Republic and everything we know that took place in the sentencing, the prison. I'd like you to please ask us objective presence. Yes, we're running out of time, sorry, but the objective question. With all this that we are seeing, judiciary and even Brazilian justice are in crisis. In events that involve even this institution, they are in crisis. Can we believe in them as a society? I thank you for your participation. But since it's not really the subject for a panel, I'm going to allow to hand over to Justice Nancy, because this involves questions that are not really those that are being discussed here between us at the moment. I apologize and request your understanding. Justice Nancy? Yes, thank you, Justice Maria Teresa. I'd like to thank and congratulate the speakers, but I was really truly impressed with the speeches that brought really important knowledge. I'm going to ask Professor Daniel Machado, because he spoke about an extremely delicate area. And I'm going to expose this or talk about this question. In Brazil, we have specialized clinics in artificial insemination. But since it's very expensive, people have been using domestic insemination, so to speak, to reach their objectives. The last case that I judged was an insemination through the use of a stereographic pen. And a girl was born. And justice was not authorizing to put the name of the second mother on it. The first mother, no problem, but the second mother, and not even that of the father. I'd like to ask you, if you've already faced something similar, how is this in Japan? So it would be two mothers and no father? So the two mothers, basically, they had homoaffective, homosexual union, and this girl was born from this kind of domestic insemination, and the two mothers did not want to inform the father's name. They just said that it was a friend that gave them this service, helped them with this. Thank you very much for the question. Justice, an honor to receive the question, even because I read actually about this case in an event earlier this year that we had in Japan, where a Brazilian professor commented about this. So preparing myself briefly for this, I was able to read about this sentencing. Well, In Japan, unfortunately, I do not have any information on regulations on the homoaffective relations. So there is no legal or decision or law related to the parentage of two mothers or two fathers. It is possible to have more than one father if they use simple adoption, because simple adoption exists in Japan, so allows the creation of multiple connections between fathers and children, parents and children. So, but it's complicated when we're talking about the relations between the parents and a minor, because there's some requirements that would demand the authorization of the family court in Japan, and there are other things that could make the use of this institution more difficult. There is not enough legislation. So I believe that in this regard, Brazil is actually far ahead of what we are in Japan. On the other hand, on the first question related to the artificial insemination, the first case we have in Japan, we have on homoaffective unions that recognized the application of the matrimonial rights for the civil unions was on the case of two women that used artificial insemination, domestic artificial insemination, to have a child. But the case is not related to parentage. It's about the relationship that was terminated, which in this case, one of the women got involved with the part that was donating the semen to do the artificial insemination. And so they ended the relationship because of infidelity, and the author of the action is suing the partner because of infidelity. This is the case that I am aware of in Brazil, but so in this aspect, I think Brazilian law is a bit more advanced. But we have two recent laws on assisted reproduction in Japan, which I won't go into the details because of time, so we can have more questions. Thank you very much for your question. I have one last question over there before the microphone reaches them over there, because we have to respect lunchtime. I would like to ask a question. Having Justice Nancy in front of me, if Japan has some regulation on digital inheritance, or transmitting digital assets through inheritance. Well, that's difficult because that's not my area. I'm specialized in family law. I deal really with family and not exactly succession or inheritance, but I know there is something. It's a recent reform dealing with digital wills, which is changing. I don't know if this reform is gonna cover the digital will or inheritance, but we're gonna have an event in September in the University of Tokyo, where we'll have the honor of receiving Professor Flavio Tartucci. We're gonna talk about this specific subject, and one of the professors participated in the legislative committee on the reform on succession law. Will be the counterpart on the Japanese side, who would be far more capable to explain and talk about this. Since the event will be in English, should you be interested, I believe it will be published at some point. So you'll be able to see it then. Thank you. Thank you, because Justice Nancy, nothing's easy or simple, sorry, with her. It's not enough for it to be digital inheritance. They want to know when they leave something, when there is no password left, how can you access it? So Justice Nancy is already called upon to follow this Congress that he mentioned. So the last question.
Can I go ahead?
Precisa da tradução.
Okay. I'm Mr. Yoshida from Gandon University Foreign Studies. And thank you very much for a series of thought-provoking panels. I have a general question about the topic of panel one, especially the privatization of public law. And because the privatization of public policy concerns to protect the vulnerability is right now one of the most important topics in contract law. I mean, the conservative big companies try to use arbitration to avoid the protection of vulnerable parties in the field of labor law or in the consumer protection law. I mean, I talk about the tension between private autonomy versus public protection. And so my question relates to the previous panel, but nobody mentioned these important issues explicitly. And right now, based upon this and American federal Supreme Court justices endorse this conservative movement, and based on the New York Convention, it's right now the internationalization of American standard is going on, and we have to, as an international community, we have to face with this conservative movement of privatization of public policies in the United States. So I'm curious about the speaker's comments and suggestions about this very serious international movement from our perspective. Thanks.
Thank you very much for your question. But since it's regarding the first panel and not this one, I will request, yes, but not by those that are currently sat at this table here. So I would suggest that during lunch, you kindly speak with Professor Oscar Vilhena, who was the one that presented in the previous panel, who I am sure will be able to better answer to your question, because he also knows a lot about this stuff. So Professor Oscar, during lunch, will be able to talk with you.
Professor Masato gostaria de falar?
Professor Masato, would you like to say something? Would anyone here be able to or like to make a comment? Yes? Okay, Professor Hajime will speak.
Okay, thank you very much for your question. This may not be directly relevant to my presentation, but I really share I share the concern of what you said, because I think what I mean by we is a kind of constitutional legal scholars, because my area is a constitution, but constitutional legal scholars thought was that kind of private issues, public issues, and if something is a private issue, then the public should not intervene because, well, there's a, private rights. This is kind of traditional understanding as far as I understand. But I think one really big issue here is that maybe the role of private actors are really too strong. Then how public sectors can intervene or sometimes restrict the freedom that private sectors has. Then, well, to be honest, I have no answer, but I think this is really fundamental challenge to our kind of traditional understanding of private public division. And sometimes one possibility would be, well, public should intervene in private matters, but that may be something that the repeating of the history of the kind of constitutionalism's movement, because constitutionalism began because public to intervene in private matters. Then, like, in order to prevent that, this took place. So I don't know what would be the solution, but I think it's really important for us to think about our assumption has really changed right now. That's all I can say.
Muito obrigada.
Thank you very much. But I still maintain the proposal, Professor, that you also speak with Professor Scarbiliena during lunch, anyway. And I hand back to our Chief Justice, Airman Benjamin. Very well. We're getting close to lunchtime now. This is the good news I have to bring to you. The other good news is that we have had a splendid morning in exchange of knowledge, especially on a subject that is of importance for everyone, not just Brazil and Japan, the whole world. That is the privatization of private law and the publicization of private law, and not just with countries that have recent constitutions, but even with countries that, although they have older constitutions, the judiciary has been looking to make private law more public or more private the public law that in traditional concept were restricted to just public law. And this applies itself to all legal disciplines, to civil law and the penal right, and it's not evident. And so we have several institutes of the penal institute that are receiving a kind of privatization. And I'm not trying to make any judgment of whether it's good or negative. In fiscal law, consumer law, that goes into its own category. That's where we have this division between public and private law is not done. And the question that is going to be left to us is if we can really speak about public or private law. If we should not perhaps recommend, and it would even perhaps be more correct, to identify the characteristics that all legal disciplines and pillars that legal discipline should observe. The first one being the pillar of human dignity. It is impossible, it's not possible to imagine that there can be any legal discipline that does not put the dignity of the human person as the center, such as a point to gravitate around. And here, dignity of human person broadened in the sense of dignity of life and the planet's life. And the second point is the principle of, and that has its reflection in all civilizations, not just in legal regimes, but in all civilizations of the world, which is that of solidarity. We cannot imagine a law, be it private or public, that is not based on solidarity. The individualist perspective has another reading. It's in respect of people's privacy, but not in the sense of giving a single individual the possibility of dictating rules to the collective as a whole.
And in third place, something that was also mentioned here is the pillar for the protection of those who are vulnerable. And once again, there is no great civilization in the world that has not, in its evolution, acknowledged that it's not the possibility. We have the duty of working with solidarity, mainly when it comes to the protection to the vulnerable individuals. With all of these minimal fundamentals and foundations and others, among others, we have a kind of construction that is going to guide the principles, guide the private law and the public law. And I'm very happy that in the several presentations we've had today, these topics, they were discussed in an open manner and sometimes in an implicit manner in the lessons that were taught to all of us. So let's continue the Congress this afternoon. I would like to thank my dear friend, dear friend, Justice Maria Teresa, in a special way. I should have been here to introduce her, but I was taking care of some administrative matters here near this auditorium, but I was taking care of certain things of the court, and it was not easy. This court is formed, and I believe that our Japanese colleagues are gonna be able to have a tour. It has 4,300 employees. It's a small town, right? Everything happens here at this place. We are 33 justices and 4,300 civil servants or employees. We have a budget, and that's what I was taking care of a while ago. We have a budget that is greater than the budget of many ministries that the executive branch and the presidency have. And it shows that we are gathered here today to debate these legal topics, but there are many administrative issues, and I'm justifying myself for having left the auditorium and for not having introduced Justice Maria Teresa. She's a professor at the University of São Paulo. We have the director and the deputy director of the University of São Paulo, and thank you so much to both of you. Next year, the University of São Paulo is going to celebrate its 200th anniversary, and we're going to have the opportunity to celebrate all of this together, this event that is very important. Justice Maria Teresa is almost like a walking, talking encyclopedia, and she is very modest, and she's a bit uncomfortable with everything that I have been saying. And I'm talking about lunch, and what about lunch? Lunch. Translation apologizes. She's not speaking into the microphone. I cannot hear her.
Durante o almoço, podemos ou na parte da tarde?
Can we answer your question during lunch?
Não é
Me?
exatamente meu tema.
It's not my main topic. Family law and also Justice Nancy. So, right after lunch, we justices from the National High Court of Brazil, we are very accessible, mainly to discuss topics that have already been judged and analyzed. We cannot discuss topics that are still being judged and analyzed. In terms of logistics, the STJ has 3 restaurants. I would like to invite the Brazilian professors and the Japanese professors to go to the restaurant we have on this floor, and also the judges that are taking part via Ajufe and AMB, the 2 associations of judges. So I would like to ask the protocol department to help the other participants and show them to the restaurant downstairs. And I already would like to tell you that the food is really good, really diverse, and I'm sure that you're going to enjoy your lunch. So we are wrapping up this morning session. Thank you so much for being here, mainly for the panelists on this panel. Thank you.
Só um minutinho.
Oiê! A moça pegou no...
Senhoras e senhores,
Ladies and gentlemen, moving on with the second STJ Brazil-Japan Law Congress. We now have panel 2 that is going to discuss trends in private law. This is the main topic of the panel. As the moderator, we have Her Excellency Justice Daniela Teixeira from the Grand Chamber of Private Law. And as our speakers, we have the Director of the Law School of the State of Rio de Janeiro, Professor Carlos Edson Monteiro Filho. He's the Dean of the Law School. Professor Yan Shan, Professor of Law of Guangdong University of Foreign Studies in China, Kunihiko Yoshida, Professor of the Hitotsubashi University Law School from Tokyo, Mr. Ichiro Kobayashi, Lecturer of Environmental and Urban Law Specialization Program at the University of São Paulo, USP, in the city of Ribeirão Preto, Professor Thiago Trentinella. I would like to pass the floor to conduct the work, Justice Daniela Teixeira.
Agora foi.
Good afternoon, ladies and gentlemen who are here today. It's a great joy for me to be here with you, attending the second STJ Brazil-Japan Law Congress. Besides the great friendship that unites our two countries, we have many things in common when it comes to private law. The private law in Brazil is very recent, as well as in Japan. The civil codes in these two nations are very similar and more recent when compared compared to other nations, so it's a great joy to be here. Before introducing the speakers, I would like to mention the richness of the debate we had this morning. Justice Maria Teresa and Justice Salomon, the publicization of the private law, or the other side of the coin, which is the privatization of the public law, from the Brazilian as well as from the Japanese perspective, gave us a clear photograph as how in this new world, this new century, the kinds of law they are mixing up. It's impossible to talk about the private law without a perspective of the public law, ensuring the rights of these private entities. And it's complicated to talk about public law as well without mentioning private law. Two fields that were far, far away, they are now closer than ever when it comes to their main aspects. The Chief Justice of the National High Court of Brazil, and I'm speaking to our Japanese colleagues, and the President, Edson Fachin, is a great authority on this topic. One of the most special books that we have about this publicization of the private law was written by His Excellency Justice Fachin before he became a justice. It's already considered a classic. It's called Civil Law, Transformations, Purposes, and Ends, and he analyzes the principles, the values of our constitutions operating directly in all of the private relations that we have here in Brazil. So for us in Brazil, it is a certainty that the topic of our panel that is called New Trends in Private Law is a certainty to say that based upon our Constitution of 1988, the greatest trend is this publicization of the private law, is to analyze the relationship that was only between Mary and John, or A and B, and now it has a constitutional foundation and a constitutional ceiling. It cannot happen outside the limits set forth by our Constitution. The Japanese Civil Code was enacted in 1898, and our Civil Code that came after 300 years was enacted in 1916. So the two civil codes, they kind of appeared at the same time. There's only an 18-year gap. And so we had an amendment and updating here in Brazil, but most of what we had in the first civil code is still remains. In Japan, we still had a great evolution. It's a civil law after World War II that was influenced by European traditions, mainly when it comes to family law, women law, and it's similar to what happened in Brazil. And along these lines, we're going to continue with panel 2, and we're going to talk about private law. And here we have a team, a multi-continental team and a multidisciplinary team with experts that are going to discuss Brazilian law and also Japanese law that happens in our friend nation. We have a professor that is going to speak first. Professor Carlos is going to go first. Is that correct? No, he's the third one. Can you please tell me which professor is going to go first, please?
Vamos seguir esse? Ok.
Let's follow this one.
Ok. Pronto. Esclarecidas as dúvidas,
So, the first speaker is going to be Professor Kunihiko Yoshida. He is a Yushan Professor of Law, equivalent to the emeritus professor that we have at the Guangdong University of Foreign Studies in China. He is a professor at the Hokkaido University. He has a PhD from the University of Tokyo, Professor Yoshida has a wonderful international career. He has taught at Northwestern, Stanford, Colorado. His most recent studies about properties, household, and justice for the indigenous populations, such as the Ainu in Japan, is going to share a precious dialogue, and we're talking about the tutelage of vulnerable society. So it's with great joy that I would like to welcome Professor Kunihiko Yoshida, and you have 15 minutes, sir, to give your presentation.
15 minutes.
You have 15 minutes, sir, to give your presentation.
I will let you know, okay? Thank you so much for being here with us.
Thank you very much for this occasion. I'm Kunihiko Yoshida, affiliated to, right now, the Gandon University of Foreign Studies, located in Gancho, the southernmost city and the third biggest city in China, after retiring from my previous Japanese university. And listening to this morning's session about bilateral judicial collaboration between two countries, my personal agenda regarding the topic is as follows. First, I worked on Japanese Brazilian atomic bomb reparation cases. I met with the chief plaintiff in São Paulo. And secondly, Brazilian Minamata disease due to mercury contamination along the Amazon. And I stayed at the indigenous village for about a week. And I also visited some other areas, Para State, Roraima State, and Amapa State. And third, I also worked on and curious about the Latin America legal pragmatism that is vibrant, and that is contrasted to the formalism backlash we have right now in Japan. And fourth, I'm also working on expanding international cooperation of Ainu Brazilian people. And recently I'm surprised to realize that here in Brazil, there are many Ainu people, the indigenous people in Japan, congregates in Hokkaido, and surprised to realize there are in this country so many Ainu Brazilian people. Okay, let's start. And first, about civil law, it's already introduced. It's a more than 120 years old code. And it's called the fruit of comparative jurisprudence in the year of 1912 by Professor Nobushige Hozumi, one of the drafters of the present civil code. It's interesting. It was first drafted by the famous French law scholar named Gustave-Émile Basnat, and who all the way from Paris to draft the Japanese civil code. And then when the present civil code was promulgated, there's a British law school and on the one hand, and French law school on the other hand. And after the 19th century, turn of the century, we had a strong German law influence. Japanese law should be interpreted in those days like German law, regardless of the field. And that position continued until the 1960s. And then my mentor, Professor H. Hoshino, revolutionized that situation. At the basis, we have Japanese law, we have a French law tradition, and he discovered a lot of concrete cases and that was biased, oriented toward German law, but it should be get back to normal, original position. And yeah, that's the history of our code itself interesting. But today I'm also talk about the civil law scholarship. And my assertion today is very simple. There's a drastic change, and there's the former Japanese civil law scholars' position is very attractive, was very attractive, but it's due to its recent drastic change, the civil law scholarship in Japan might be dwindling, and civil law education itself in Japan overwhelmed right now by manualism. It's very different than the position of my mentors. And I prepared 6 slides, and that includes a lot of pictures. So please get relaxed to enjoy my pictures. Okay. And thus, in this way, there's a big discrepancy, between the present code-oriented civil law scholarship and emerging, expanding new fields of civil law, such as housing or living welfare law, or reparations, indigenous peoples' law, and what not. And we have to look for the good legacies of the Japanese legal scholarship in the face of this situation. First, we used to have a legal realism and pragmatism. That's very exceptional in East Asia under the strong influence of American legal realism movement in the 1920s and 30s. But as I already mentioned, we have recent legal pragmatism in Latin America. I'll tell you more about that by showing you some pictures. And second, high quality of legal education and legal research in quest of original forefronts in the scholarship and its attractiveness among my mentors. For example, my mentor, Professor Hirai of tort law, in his case, his critical tort law that I attended when I was a student at Tokyo University was very different from the mainstream tort law. That's very academically very interesting and thought-provoking, even for students. The young students are very sensitive to what the teachers are doing, manualism or creative, thought-provoking, forefront research or not. They have the sense of knowing. And third, broad scope of research. For example, Professor Hoshino, my mentor, often told me the civil law imperialism. He's using his book, Centennial book, has been published very recently due to the great efforts of Professor Ninomiya. And he's using this term, civil law imperialism, in the positive way. He always mentioned the civil law as foundational law should be broad enough to include everything, especially socially important issues. Okay. And fourth, there's a competitive critical discussions, vying for the original shocking statement, as opposed to authoritarian top-down interpretation that might stifle counter-majoritarian arguments. And fifth, academism. Okay. And I already talked about legal pragmatism in Latin American countries. I felt that atmosphere when I attended the SU Buenos Aires conference last month. And this is a picture with Professor Hernandez at Los Andes University in Colombia, or Dean Shetman in Buenos Aires. And they both talk about the legal pragmatism, policy-oriented argument that is missing in present Japanese scholarship. And for example, the traditional justice field, they are spearheading this pragmatism. And this is one of the tourist spots, and Christ Redeemer at the Corcovado in Rio de Janeiro as a symbol of reparations and transitional justice. And many Latin American countries try to overcome past injustice as laboratories, very vibrant and competitive, to improve the situation. But it is nothing. It is missing in Japan right now, despite a lot of past injustice in foreign countries. And yeah, I skipped this, but yeah, the interdisciplinary encounter with Dr. Hayakawa, especially in the field of housing and welfare, is meaningful in my legal scholarship. He also mentioned the same thing. The research should correspond to current agendas. And today's talk is one of the essence of my latest monograph about the environmental crisis, climate change, social solidarity, and the agendas of civil law. That's the topic. And right now I'm from Gancho, and this is one of the tourist spots, and Mr. Sanyatsen focus on common good and fraternity, social solidarity is really the important agendas in the civil law in the 21st century. Oh, it's okay. Okay, let's move forward. And I already mentioned everything, and I'm going to leave the slide here, so please enjoy it afterwards. And I just mentioned the current important issues in 21st centuries, aging society, post-industrial consumer society, or things like globalization, growing disparity between the rich and poor, or things like that, disaster recovery. And according to Professor Hoshino's civil law imperialism, all these issues should be included in the civil law topics. But on the other hand, the mainstream civil law scholars is narrow. According to them, those important issues is outside of their scope of civil law education. That is very problematic. And I already mentioned this, and I'm happy to show you a lot of slides. Exceptionally, as I mentioned, the Japanese legal scholars are very much influenced by the American legal realism movement and related people. Professor Suehiro, at the beginning of his career, he very much studied about the German law, but he could not go to Germany because of World War I, and he changed his mind to study in the United States. So he's the first Japanese civil law scholar, very influential scholar, who first experienced the American law school education. And he's a substantial student, Professor Kawashima, and he's also influential. According to them, this Tokyo University tradition, the civil law scholars should be generalists, should adapt in legal theories, or as well as specific dogmatisms, legal arguments. And this is a picture when I visited his house last. in the same year, he passed on. And this is the picture of another mentor, Professor Hirai, who's the founding father of the Japanese law and economics education and the interdisciplinary. But these days, interdisciplinary argument is gone among young scholars. So and my mentor's mentor, Guido Calabresi at Yale, he's still active. He's as Benjamin, just Benjamin, he's missing, but he's also working as a judge of the Second Circuit. And my mentor, Duncan Kennedy, is the leader of the critical legal studies at Harvard. And another mentor, relational contact theory, Ian McNeil, when I was at Northwestern in Chicago. So the problem is these, I already mentioned that. And as a matter of fact, there's a big disparity between code-oriented studies and socially important issues. For example, the law school education subjects are much smaller than the actual scope of the civil law issues in its real sense. The actual matters might change the traditional paradigm, I think. For example, the repatriation of looted Chinese culture property. This is a picture at the entrance of the Oriental Research Institute of Tokyo University. But those two stone lions might be looted from Beijing, from Yihuoyuan. And this is another problematic place. And the original stone lion was looted and right now exists in Yasukuni Shrine. And this first conference of repatriation of culture, looted culture property has been held in Sao Paulo by the foreign ministry in Brazil. It's a big conference, and I organized as a Chinese scholar the panel of repatriation of Chinese culture properties. And this is another picture in the West Banks. And the only place the local resident can live is the cave. All the original houses are destroyed by the Israeli armies, and their residents are designated from top down the exercise place of the armies, and it's miserable. And okay, I'm sorry, I have to skip all of these. And another Brazilian topic is a Brazilian Minamata disease, and those places are really heavily contaminated by mercury. And I met with this woman, Rachel Leal, in the Amapa state, and she herself already suffered from the Brazilian Minamata disease. Okay. And look at this, the river water is opaque. And unlike the village master's childhood, when the river was transparent, you can't see anything. The fish, or there's no single bird there. This is the situation of the Amazon, contaminated Amazon. And we held a meeting for local school teachers to ask kids to avoid the carnivorous fish, but to eat the herbivorous fish to avoid the contamination. But this is the only thing we can do at this moment. Unlike in Japan, the litigation doesn't work. Okay, we can't make a lawsuit. This is the picture taken at Korean Supreme Court. One of my close friends, Justice Young, one day in October 2011, asked me to have dinner together, and I drank beer, and then Justice Young, he asked me to come with him, and this is the research place, the seminar room on the top floor of the Korean Supreme Court, and I was asked to make a presentation about reparation, about Korean slave labor, so things like that. And half a year later, there's a revolutionary judgment issued from the Korean Supreme Court. And this is a picture with Korean leading scholar of Enfam University, who led the argument to comfort women issues. And another picture, it's about the Chinese tragedies of her family were killed at the Nanjing massacre. She herself was stabbed to death and almost dead, okay? And all the inner tombs were looted by the Hokkaido University professors. And right now, the repatriation is started. And this is a picture when I met with Takashi Morita, the leader of the plaintiffs of the atomic bomb reparations lawsuit. Exceptionally, that lawsuit is very successful and changed the world exceptionally. But he passed on the year before last. And this is another picture with Mr. Morita in Sao Paulo. And right now, that grocery store was run by his daughter, the Yasuko Saito. Okay, this disaster recovery is another big issue that should be included in civil law, but mainstream civil law scholars are just indifferent and to this very important field. And sorry, this is the, okay, end remark. The recent change of Japanese legal education and research is drastic, forgetting our past good legacies. We are overwhelmed by Chinese graduate research students, while those in Japan and Korea dwindle. But we need to change this situation by broadening our view of civil law and by learning from the actual cases in the crossing fields of civil law and international human rights law. Doctrinal studies are necessary, but they should be spearheaded by theoretical and political threads as a legal pragmatism in Latin American countries. The future of the East Asian legal scholarship will be overwhelmed by Chinese legal scholars, sad to say, though its direction remains uncertain. Teaching Japanese promising research traditions as good legacies at the Ganda University of Foreign Studies represents my mission to bridge these divides and reimagine East Asian legal education for our challenging era. Thanks for your attention. These are the reports and of my class students. And some of the promising papers argue that my class is transformative in the sense that it's comparative, interdisciplinary, and both empirical and theoretical. Thank you for your attention.
Gostaria de agradecer em nome do Superior Tribunal de Justiça ao professor.
I'd like to thank Professor Yoshida in the name of the STJ for his presentation. I think it's clear to all of us that the problems in the world are all very similar. Put here in the table several subjects such as the question of feminism, the pandemic, aging of the population, difficulties of law in treating subjects that change quicker than laws do. And it's also shown all of us here several tragedies that took place throughout time and the world challenge of trying to deal with this civil reparation. It also showed the importance of this exchange in the name of the world population. I'd like to thank you for this opportunity of going throughout the whole world, seeing experiences of tragedies, conciliation, and civil reparations. And this important exchange between the nations and the law schools and the courts. Congratulations, Professor Yoshida, for your trajectory. And that was shown here, dealing on civil reparations It's a great joy for us to be able to see this work of yours. I will now immediately call over our second speaker, Professor Ichiro Kobayashi, this professor of law in the Itosobashi School, director of the Center Innovation Research of Legal Questions. He deals with contractual, trade, legal, entrepreneurial practices. His recent publications, among his recent publications, are Institutional Silence in the Law Innovation Technology magazine, and has Japanese contractual law in the Journal of Japanese Law. His most recent research include the interaction between legal institutions, entrepreneurial legal practices, on a comparative perspective. Before entering academia, he worked with conformity, compliance, legal questions on the Mitsubishi Corporation. So I hand over to Professor Kobayashi for 15 minutes.
Good afternoon, everyone. It's a great honor for me to be here today. First, I would like to thank the organizers of the Second Congress STJ Brazil-Japan Law for the kind invitation and for all the hard work behind this Congress. I've been looking forward to this opportunity for a long time, and I'm delighted to share my research with you today. Let me briefly introduce myself. My name is Ichiro Kobayashi. I'm teaching international transaction with comparative perspective together with law and technology at Hitotsubashi University in Tokyo. And much of my work looks at how Japanese contract law actually works in practice. It often works quite differently from Western standards. I mean, if I say Western standards is a very global standards, the Japanese standards are a little bit different. So this is the starting of discussion. This is where my puzzle began. When global companies deal with Japanese suppliers, for example, European and United States company would have a transaction with the Japanese companies. So they often, both sides is dealing with some exchange documents. For example, the purchase order and standard terms and conditions. And then I think that both of them believe that this deal is done, but they understand differently. That is a problem. So I would like to show you how different the understanding of the contract by Japanese companies and Western companies is. That is my topic of today's discussion. And then my title is a collision of contract governance. Contract governance is a very important topic in these days. I think today's our title is the trends of private law, right? So I think the recent trend, most popular recent trends of contract law is a contract governance. Itself is very popular among European countries, especially in Germany and France. And then I would like to talk about that contract governance. Then I think the subtitle, Western Models of Supply Chain Regulation and Japanese Contract Practice. That is what I would like to talk to today. Okay. So let's start about the, I would like to talk about the supply chain and governance. Let's take a look at the right side panel. So global companies are preparing a supplier code of conduct. So which is, referring to a lot of obligation which suppliers should comply with, including a human rights obligation and environment kind of things. There is that is in the supplier code of conduct. Then there is a lot of suppliers, supplier A, B, C, D, E, F, G. So a lot of suppliers, then global companies try to implement the same obligation under the supplier's code of conduct to all suppliers of the global companies. And this chart is not appropriate yet because this not only the supplier ABCD, there is a sub-suppliers, the tier 1, tier 2 supplier, tier 3 supplier. And then there was a so-called cascade obligation, cascade mechanism, in which says that global companies passes its human rights obligation to the supplier ABCD. Then supplier ABCD passes this obligation to the second-tier supplier. Then second-tier suppliers is passing obligation to third supplier. This is a kind of cascade mechanism, and by which this supplier code of conduct is spread all over the suppliers of the global company. That is a mechanism of the contract governance of supply chain governance. So companies now use contract to spread social norms, for example, human rights obligation through global supply chains. So supplier codes of conduct turn sustainability standards into contractual duties. So audit reporting, remediation, and fraud clauses can reach lower tier suppliers. So standard terms help global companies use the same rules in many transactions. So this form of private ordering, which is so-called private ordering, supports public regulation. It supports public regulation, which is a mechanism of the contract governance. So here is a problem at the heart of this paper. Global buyer, which is a European companies, will submit terms and conditions to supplier, but in terms and condition itself does not specify these human right obligation or supplier management kind of obligation. So supplier code of conduct is referred to by terms and condition. The problem is that in many deals, global buyer may sign their terms and conditions and submit to the supplier, but supplier is not always giving signed back to global buyer. So then supplier will perform without signing the terms and conditions. That could often happen in the daily transaction. And sometimes the terms and condition is submitted by email. Yeah, attaching the supplier terms and condition with the email. But supplier says, oh yes, okay, or something like that, but it's not concrete contract signed by both parties. That could always happen. So that is a problem. So two companies can follow the exact same steps and still disagree about whether they made a real binding promise. So generally speaking, global buyer believes that they have a binding contract, but Japanese supplier does not think that there is really a binding contract. That's a problem. So Western buyer may believe the deal is settled, but Japanese supplier may believe it is still open. That could be a problem. So there's a main question. When does this kind of clause really work? I mean, it is said that European companies believe that the supplier's code of conduct is binding against the Japanese supplier, but is it really work? That is a main question. So the two sides may not even agree on what makes a deal real. So to answer this, the paper asks, this presentation asks 3 follow-up questions. How does contract law treat agreement differently in Western and Japanese practice? This is the first. And second, who end up paying the cost difference before, during, or after the deal? And third, when real harm is found, what turns a signed promise into real action? This is the third question. We will have to answer these 3 questions. Okay, and I would like to study the comparative contract law and institutional analysis to compare 2 ideal types. So let's take a look at the right side. In Western model, buyer will offer of the standard terms. This is an offer. It's in terms of offer and acceptance. This is the offer. And usually supplier will start to perform. If the performance is considered to be acceptance, then between the buyer and supplier, there was the offer and acceptance. Then the contract is concluded. That is a Western model of contract formation. But in Japanese model, it's not the case. Buyer and supplier, it is still believed that in order for contract to be concluded, those two parties must sign the contract. That is a long traditional proceedings of the Japanese courts. So buyer and supplier try to make a deal by signing the contract. Signing a contract is very important in Japanese contract practice. So, but it takes time. Then they started to performance. So it means buyer and supplier performance starts. And after that, they negotiate the terms after the performance. That happened. It's very awkward, but the negotiation is still ongoing after the performance is started. That is very awkward, but it's a Japanese model. So these two are very different. So main point of comparison is the formation is different. Incorporation timing is different. Maybe responsibility is different. And I think renegotiation is more important in Japanese model. So that is the difference between the Western and the Japanese model. So Western standard model is, again, buyer will submit the offer of standard terms. Then this is offer, and the supplier will accept by performance. And CISG, Article 18 says starting performance may show acceptance. So that's why it could be possible that contract is concluded by performing by supplier. So because performance can count acceptance, the buyer can refuse to negotiate the standard terms at all. So buyer says, I give you the offer of standard terms, then you perform. So then the contract is concluded under the buyer's standard terms. That is the logic of the buyer in order for its own supplier's code of conduct to be binding. So a major European company is having a policy of no negotiation policy. I mean, this is my policy. You cannot negotiate at all. So if you want to negotiate, you cannot deal. So walk away. That is the no negotiation policy that still reduces contract and compliance management costs. So I think it is that's why they believe that this kind of supply chain management by compliance is very effective by the European companies. But Japanese contract practices are still different. As I said, they often start by performance. So after the performance, then terms is still being worked out. So in Japanese practice, contract become binding only after both parties carefully work out the agreement together, step by step, and put it into a signed contract. So starting performance alone does not make the term binding. So that is a different thing from the European practice. So different understandings in one supply chain, the same clause and same act of performance, it is the same thing, but a little bit negotiated is ongoing after the performance. That is a Japanese standard, but that difference, the same clause and same act of performance may mean different things to the buyer and the supplier. So global buyer may see its code as a final and binding duty, and the Japanese suppliers thinks that without a signature from both sides, the Japanese supplier may see it as a general policy or a topic for a later discussion. So this difference may remain hidden while the transaction runs smoothly. Then it becomes clear when the parties must audit, remediate, share costs, or end the contract. Then it becomes clear there was some misunderstanding between the two parties about the understanding of the situation, station, the contract. So please take a look at the right panel. There's the famous bottom of the forms in the Western practice. So Western companies often send each other different contract terms and still start to work anyway, and creating a dispute over whose terms apply. It's a so-called last shot rule and knockout rule. There is some kind of interpretation, but there is a lot of battle of forms in Western practice. But Japan has almost no dispute like this, no battle of forms at all in Japanese practice. So this may show that in Japanese practice, standing work alone does not create a binding deal, right? So it's the understanding about the performance is very different in terms of the contract interpretation. So three forms of effectiveness could be thinking. This agreement just we saw is really a question of effectiveness. So three levels of effectiveness. First of all, first one is the legal effectiveness. Clauses incorporate and enforceable. So Western company says it is enforceable. Japanese companies say, oh, it is not enforceable. So that is the first level or legal effectiveness. And second one, the managerial effectiveness. The company has systems of audit, reporting, documentation responsibility. That effectiveness is the second one. But the point is the third one. Sustainability effectiveness. The party actually prevent, find, stop, and remedy violation. So this is a sustainability effectiveness. The problem lies in this sustainability effectiveness, because Japanese company says, oh, its standard term is not binding at all. So a Japanese company does not prepare anything about the supply chain management or human right obligation. So, but European companies believe that Japanese companies preparing for the supply chain management or some audit kind of things, because they submitted terms and conditions. They believe that Japanese corporation understand the binding obligation, but Japanese company does not believe it is binding. So that's why sustainability effectiveness is not effective. So different problems addressed by contracts. Sustainability clauses have a different function from contracts for ordinary transaction between two companies. So real control is often out of reach. It is quite dangerous. It can feel easier to avoid getting caught than to actually fix a problem. I mean, first two-party global company, direct supplier, there was a full control. So direct supplier tried to avoid any human right obligation problem or any other problem in relation to the supply chain management. So direct supplier tried to do that by myself. But for the second, lower tier supplier, direct supplier cannot control over the far for second, third, tier 2 and lower tier supplier. So control phase with distance. So that's why direct supplier says, okay, we have no obligation legally. So I do myself within my control, but out of control, we don't do that. Because if we try to control and find something, that could raise a problem. So the direct supplier do not do any control over this tier 2 and lower tier supplier. That could be our problem. So that there is a decoupling, formal compliance and actual practice. So take a look at the right side panel. So what everyone sees, audited, reported, compliant. This is what everyone can see on the face of the transaction, but reality is not the same. So there are two codes. what cause A is going through the motion. It pretend to comply with the supply chain obligation. This is cause one. So in order to fix that, independent third-party verification is very necessary. Okay, and for cause B, this is a problem of the different contract practice. Never really agreed. So European companies think that it is agreed, but Japanese companies said it is not agreed. So in order to fix it, confirm what was actually agreed to. This is very important. So conclusion. People often say standard contract terms have successfully spread sustainability norms across supply chains, but this success story rests on the hidden assumption that both sides agree on when a term becomes binding. So when practice in Japanese, Western practice and Japanese practice do not always share this assumption. So the same contract may feel settled to Western part, but still open to the Japanese side. So this gap stays hidden until real problem appears. Then it can slow down the exact cooperation that is needed most. So legal form has its place. It gives a company defensible position if a dispute goes to court, but form alone does not stop harm. So in conclusion, what actually matters more is steady day-to-day work between the two sides built up before crisis, not scrambled together after one. That is the conclusion. So thank you very much for the kind listening. Thank you very much.
Gostaria de agradecer, professor.
Thank you very much, Professor Ichiro Kobayashi, for your presentation. And you have shown to us how our civil codes can be so different, yeah? The importance of global companies using the same standards and rules and norms in their transactions. And the terms and conditions should be previously set. And you showed a real example, as said on the panel. Sometimes people do business without signing a piece of paper, and the differences in practice. And the Japanese practice, as Professor Kobayashi showed to us, they are way more formal than we are. Here, Professor Kobayashi, we have a lawsuit called Monitoria lawsuit. It came with our new civil code, and we allow them to charge the values owed without an executive bond or title. So you have a lawsuit, a specific lawsuit to request a right that was not previously signed. So thank you. It was wonderful to watch your presentation and see the differences between the Japanese companies and the Western companies. Justice Miyajima and Carlos Murta, the justice, they are here. I had my eyes operated on Friday, and so I cannot see very well. I had an eye operation on Friday. So I apologize for the two of you because I didn't see you when you came in. You are justices here. I would like to pass the floor to the Brazilian part of our panel. Let's start with Professor Carlos Edson Monteiro Filho. He is a dean of the Rio de Janeiro State University Law School, the UERJ. He is a civil law professor at UERJ. He is a professor at the Coimbra University in Portugal. He is the head prosecutor from the prosecutor's office of the state of Rio de Janeiro. He is member of the Bar Association. He has a master's degree and a PhD degree, and he's also an attorney. So I would like to pass the floor to Professor Carlos Edson for 15 minutes. Now, let's see the Brazilian perspective of the trends in private law. Good afternoon, ladies and gentlemen. It's a great joy to be here. I'm going to start my stopwatch, okay, so that I can give my presentation within these 15 minutes. I had prepared a presentation to discuss three aspects: the trends in private law here in Brazil, But given that this morning we talked a lot about the contract part, and now more recently with the approaches carried out by Professor Kobayashi, I'm going to only discuss two aspects with you so that we can continue discussing the topic, okay? I'm going to talk about other topics. Contracts, let's consider that this class has already been taught. So it's a great joy to be here with you. This event, once again, emphasizes the importance of how important it is for us to compare everything, to do comparative law that has been growing around the world. When I was an undergraduate student a few years ago, compared law was seen, or comparative law was almost considered to be something superfluous, yes? And so the professor was trying to show off a little bit, and he usually traveled to Europe or here in South America, and he would visit the bookstores and he would buy the civil codes. He would buy the civil codes from other countries, and then he would say, in Italy, things are like this. In Portugal, things are like this. In Spain, things are like this. But only using the civil code of these nations without discussing the other elements, about the jurisprudence. And so now we have advanced a lot. And Chief Justice Herman Benjamin should be congratulated. And Oscar mentioned this earlier today. This is an opportunity to compare with unusual destinations. We still compare Brazil more to the USA, to South America, and to Europe. But now that we are comparing with Japan and China, this is opening new perspectives so that we can have another kind of comparison. So formidable. Congratulations, Chief Justice Herman Benjamin. I would like to greet all of the deans of universities here, my friends, prosecutors, justices, and everybody here.
I was also really happy with the summary that Chief Justice Herman did here at the end of this morning's presentation, saying that the tendencies of private law was to structure itself in three fundamental pillars, where we have the principle of social solidarity and the tutelage of those that are vulnerable, foundations that, according to him, create a framework, and also public law, showing the overcoming of this addition between private, or division between private and public. And so we can sum up these factors as a true tendency of private law.
Temos programa de pós-graduação em direito, a nossa linha de direito civil já tem mais de 30 anos.
With this, that has been going for over 30 years for public law, and now we are talking with Dr. Junqueira. We call the Rio de Janeiro School, which is a constitutional civil theory. And is an optic that values the application of principles, that values the unity of the organization, that values the making the functionality of this, where you have the existential values that are at the peak of that. So we're really happy this school, since our integration with Italy. So we have Capo Scola, where we have in Brazil, we have Pacho Pergino, Professor Maria Celina Modani de Moraes, and also that was mentioned by Justice Daniel, Professor Edson Fachin, that was a visiting professor in our graduation program very often. And we have the partnership Brazil-Japan, which is the object of this event. Aside from the judiciary we talked about here, in the judiciary between Brazil and Japan, the balance between our trade between Japan and Brazil, all these macro aspects, in a micro perspective, in our little world of the law school, we also have a very lively partnership with Japan. And this started through a personal initiative, Professor José Marcos Domingos de Oliveira, that was there in Japan. And then we perfected this. Today, this exchange Professor Domingos inaugurated in Japan was followed then by many students, or ex-students, now Roberto Arapedo from the University of Nagoya, that will speak tomorrow. And that is now teaching at the University of Nagoya. And also professors of ours that went there, such as Professor Gustavo Siqueira, that is also present here. That is a partner of the Japanese people in other events as well. And in the Federal University of Rio de Janeiro, we've developed a Japanese studies classroom. There was a donation of the Japanese people through the Japanese consul in Rio de Janeiro. When we inaugurated, it's a spectacular room with several events. We had events now on the 12th of August and the 11th of August as well, in the Brazil-Japan classroom, that has many technological resources. Brazil, we always associate Japan as the peak of technology. And so we received the donation of really leading technology. And we also have a bilingual book that was published last year, Triangulate with Italy as well, with the illustrious Professor Mario Gozano, that was there speaking for our students, that lived with disciples of Alberto Bobbio, and they exchanged letters with Hans Kelsen himself. So, subject with a really extraordinarily rich tradition of law. And so we published this book. It's coordinated by Professor Junqueira, that's also present here. We also have in Japan the JICA organization that always finances the arrival of a Japanese professor per semester for the University of Rio de Janeiro to debate with us. Anyway, I'm nearly at the middle of my exposition. I haven't even properly started, but I'm going to be very brief because it's important to bring this all and mention all of this, since the objective of this meeting are these organizations, which I think is even more important than what I have to say. I have very little to say. As I said, I divided my presentation into three things. One, defending negotiating autonomy, talking about the clauses that talk about the risk allocation in contracts, but this has already been mentioned, so I'm going to consider it's been done and given. And so I'm going to speak a little bit about civil responsibility in 3 minutes, and real rights as well in another 3 minutes. So what happens with civil responsibility in Brazil? There's an expansionist movement, a very big expansionist movement for civil questions in our country. Civil responsibility started very small, confined to just obligations, to now where it has spread itself with borders with many parts of law, preventing damages, the development of new technologies, everything conspired for this new organization where this is now considered and used in mass, and the risks are also ever bigger to which society submits itself with new technologies. So we have this huge expansion that corresponds to the challenge of the doctrine. Are the existing tools enough? And doctrine has been divided. Some say it is fine, that civil responsibility is monofunctional. We just need to have the compensatory reparation style, and this is what it's about. And a big part of people say is no, that this structure of the norm that in a way repeats the code of 1996 and 2002 and the code of 2002, this normative structure cannot deal with the new functions of civil responsibility, since it would have other functions aside from damage reparation, such as prevention, the obligation of preventing with its own tools, mitigation, damage mitigation. We have the preventative measures payments. This is called inhibitory tutelage. All of this to avoid the consumption of irreparable damages, to mitigate also ongoing damages. In the 70s to 80s, Professor Rando Gomes, there was a big Brazilian jurist, expressed what we were going through at that time, which was a conceptual overturning of the author of the damage towards looking onto the victim. The onlook should be directed towards the victim and no more the person that was responsible for the damages, so that we can eliminate all the effects of the damages suffered by the victim. And in this sense, Brazilian law established the extra assets or heritage damages since the Kincaid one from the 60s to 70s, all the way until in 1988, where we had a specific constitutional text where we flexibilized the rigor of certainty to the assumptions, to the flexibilization of annexes, which is very interesting in current decision without there being any excess. It's important to ponder that, and also the transformation of guilt itself that became objective in its most part, that is much bigger now. The cases that go through this forum, in vast majority, request objective responsibility, not subjective. The guilt moves to this, and even within these strict limits of guilt, guilt has been objectivated. We talk about normative guilt, no longer psychological, but the normative one that talks objectively by contrast of standards of behavior that is expected in each concrete case. So this whole transformation points to the need of this current reflection, and I will conclude in this point, of civil responsibility being thought on preventative mechanisms rather than compensatory. So it's a new new meaning to all this, which is constitutional meaning, with asset and existential principles. And I'm nearly out of time. We're just talking about real rights. Far from it being an environment of safety and stability and certain monotony that one would expect, it's actually very dynamic. Each day, it's transformed more. They're object of a very extensive and broad transformation that has been taking place in Brazil. So you can have an idea. On the Brazilian Civil Code, and here I'm talking especially the Japanese professors, there are 17 modifying laws just in the initial chapters, the real chapters, where it concentrates the most with the transformation and creation of new institutions. It's a true construction site. So, three aspects here. First, in the real rights, in regards to the expansion of negotiating autonomy in the when we're typifying real rights. But within that, there's a lot of margin for the parts to negotiate and to show private negotiative autonomy. Example, condominium conventions, the prohibition of children, of animals. This is something that the STJ is constantly discussing. What is the size of the dog? Is it big and medium? Can a small cat be or not? And just, I'll ask for another 2 extra minutes and I'll be done. And this is an important question. Autonomy also, there is a broad, Santiago Dantas, for example, big jurist, calling about the freedom to invent civil work and servants. So this is a tendency. And aside from that, the incorporation of principles, talking about contractual obligations, good faith, they start being applied very often and being decisive in solution of programs of real legal questions, the promise of purchase and sales. Numerous debates that are solved through the application of principles that are said contractual. So also break that dichotomy of real rights and contractual ones, because they are actual part of the same system, the so-called heritage or asset rights. This is a clear tendency, something that is takes place in part thanks to and because of technology, what we call the autonomous guarantees. And we also have the Martian Pact, where the guarantee owner can keep the asset so long as he returns the superfluous amount of the debt to the person that owed him the money. This is the Martian Pact, is something that already exists, is in practice. And thirdly, the incorporation of new legal goods in the agenda of real rights, such as time that previously was just a chronological factor for terms or conditions in legal business, now is itself an object of legal tutelage. And that can even bring to have moral or even asset payments, abusive charges through WhatsApp or through condominiums or cameras that are placed. Some of them refuse to enter the building because they need to give the whole biometric data to just enter into a lawyer's office. All of this is being discussed in real rights. This is a synthesis. I apologize for going over my time, but I had to talk about our cooperation with Japan since this is the objective here, and I'm also at your disposal to talk about this more deeply, both for civil responsibility as well as real rights. It was a pleasure being here with you. Name of the STJ, I thank Professor Carlos Edson for his presentation on our rights, and I speak here for our colleagues from Japan. Our civil code, after the Constitution, is Article 57, talks about the exclusion of an associate. And we're thinking about something that's completely of a private right, of a member in a club, a thing that is a personal relation between physical people. And in our civil law, it says that the exclusion of a member is only admissible if there is just cause recognized in a procedure that ensures the right of defense with the possibility of recurring and with the pre-written statute. So this is included in the civil code. This is what we were saying before. This public, where our civil code, our constitution is permeating our whole private right, and the right of defense is saying there is no crime without a previous law to define it, that to remove a member it has to be written before that what he did was not permitted by the association. So our constitutional right has invaded, so to speak, the civil one, which was considered private. I'd like to greet here our Minister, our Justice, Fátima Andrigardine, the biggest authority in private law in Brazil. Doctrine and jurisprudence. Well, she's very, very humble that she's the biggest authority we have here in Brazil in private law. It's a shame for those here at the panel who had me instead of her as the moderator, but she is my mentor and a great practitioner. Thank you for being here. And we hand over to our last speaker, Professor Thiago Trentinella. He's professor, loyal, bachelor's from the School of Law of USP. And for those who are here for our colleagues of Japan, these are the two universities that most litigate among themselves, the São Paulo University, Federal University, and the Rio de Janeiro. So we have Professor Thiago from São Paulo, specialist in environmental law and public health, master and doctor by the University of Osaka, of the Faculty of Law of Osaka, visiting professor of the University of Ribeirão Preto, post-graduation in urbanism as well in Ribeirão Preto, professor of environmental law in the University of das Cruzes. So it's a great joy for us to hear his presentation. Good afternoon, everyone. Thank you very much for the introduction. As you must have noticed, I've gone around between Japan and Brazil. I'm back for a few years now, and I'll add a date. I'm from Salvador. Doesn't look like it, I know. But since I lived most of my life in Salvador and another part in Japan, and then the other third from São Paulo, I can say I am Japanese, São Paulo and Bahia. And I will say that my presentation will be as hybrid as I am. I don't know where it is, but
anyhow, where is my presentation, please? If you can please stop the clock, because what I have to share with you is very important. Please stop the stopwatch. Go back to 0 minutes, please. Oh, okay, now my time is back. The full 15 minutes. So taking advantage of this technical problem, I'm going to talk complementing Professor Carlos's presentation, because I'm also going to talk about the civil code, but within the area which is an expert. I'm not going to say I'm an expert, because we have Chief Justice Herman Benjamin, who's the top expert. I love working with environmental law, and environmental law, when I started, was still very incipient. And then I traveled to Japan, and I moved there for 11 years. So I studied law here in Brazil, but I also learned about environmental law in Japan. And since my first degrees I got in Brazil, it was difficult for me to understand certain instruments that, even though we have civil liability for damages and the technical term is the same, Brazil and Japan use these instruments very differently, mainly when it comes to environmental law. So my presentation is going to be on the following topic. Law, private law has as an instrument civil liability, and this instrument, it can be used in Brazil to protect the environment. And my biggest question that I'm going to answer quickly is if this civil liability or responsibility instrument, is it used to protect the environment in Japan the same way we do it in Brazil? That was my research question. Sorry, I'm waiting for them to upload my slides. What's wrong? What is the technical issue, please? What's happening?
Muito bem.
Aí eu pergunto, professor, se o senhor gostaria de prosseguir sem ou prefere...
Would you like to continue? Once the slides are ready, because we have some important images. Without the slides, I can do. Would you like to help them?
Não, eu acho que é a dificuldade no computador do tribunal.
I believe that the problem is not my computer.
Continuar, e aí eu já
I can
recomendo até
continue.
quando chegar na parte das imagens, dos casos concretos,
When it comes to the
posso
cases and the
tentar me
images,
referir aos slides. Mas o ponto é o seguinte, agora me...
Então, professor, parece que a dificuldade é grande, técnica, que eu não entendo, para passar os slides. Aí eu pergunto se o senhor prefere se apresentar, por exemplo, ao final do painel da ministra Nancy.
would you like to give your presentation at the end? Ah, they managed to upload my slides. When nature sends us the bill so that we can pay the bill. So when nature sends us the bill. So now I need the clicker, please. Civil liability for environmental damages in Brazil and Japan. Oh, the clicker is down here. Thank you.
Então, a primeira parte,
So the first part, I have already discussed this with you, civil liability on environmental damages. So how the private law and civil liability and tort can protect the environment? Do they do the same thing in Japan as we do in Brazil? So I'm very happy to be discussing this topic with you and Kazu Watanabe is here. And so now I'm going to talk to the Japanese professors. Maybe you don't know the structure. Brazilian law says that environmental damage is damages caused to the environment, And when did this start in Brazil? So in 1981, the National Environmental Policy Act was enacted. 1981, that's when we started. In this act, we have a concept of environment that does not depend on human beings. It does not depend on human beings. And there is the forecasting that this liability depends on the humans. And so this first law helped us a lot. In 1985, now mentioning Professor Kazu Watanabe, that helped design and draft this law, we enacted an instrument that says that environmental law is for a certain number of people, and to protect this asset, there is a specific lawsuit called the civil lawsuit. So for the Japanese professors, it's easier to understand. Civil law with public interest. My professor, Iko Kubo, she came here last year. And to crown all of this, so we have the concept of the environment, environmental damages, diffuse right, and to crown this set of laws to protect the environment per se, we have the Brazilian Constitution that says everyone has the right to an ecologically balanced environment. Both government and community shall have the duty to defend and preserve it. So it's our responsibility. This is the legal framework that we have for the protection of the environment via the civil liability. We can also protect the environment via some government agencies, but we pay special attention to the protection of the environment via civil lawsuit that can be filed by the public prosecutor's office. In Japan, the public prosecutor's office does not have this mission, and so they have it in the penal courts and codes. Our society can also file a civil lawsuit. Something like this does only exist in Japan when it involves consumers and a legislative advance influenced by Professor Watanabe. So in Japan, they have a collective lawsuit. It's the only instrument that they have. And how do things work in Japan? I'm also going to use an image that my mentor always uses, which is the doors of justice. My professor has the access doors. So there are three pillars. The third pillar is access to justice. And she uses a woodpecker as an image, a woodpecker that knocks on the door of justice. And she uses this image of the woodpecker knocking on the door because the judiciary branch in Brazil is the door to enter the judiciary branch for environmental issues is very narrow. And so, since I graduated in Brazil, I lived in Japan for 11 years, and this is my personal opinion, that the environmental cases never reached the point that they should reach. Well, that's not really like that. So the public administration has to protect the environment in Brazil, and it leaves little space for the Japanese society to protect the environment itself. So in 1993, Japan enacted the Basic Act on the Environment in 1993, and there is a concept of pollution, of the environment, and there is a concept, a term that is living environment, the living environment, the environment connected to human beings. And what does this mean? That environmental damages, they can be taken to the judiciary branch. If there is a damage to the environment, a simple answer is yes, we can do that. We can file a lawsuit, but there is a prerequisite that we do not have in Brazil. The prerequisite means there must be an individual damage. And here in Brazil, this is possible. A damage caused via the environmental damage can be taken to the judiciary branch to require or request reparation. But in Japan, that's the only situation. We're going to see a specific case later on, how these restrictions for the civil liability for environmental damages impacts the sentences in Japan and the rulings in Japan. Going back to the image, the door to the judiciary branch in Brazil for environmental lawsuits is broad, but in Japan, it's a little narrower. And the prediction that we have from 1991 doesn't have an equivalent in Japan. 1981, pardon me, 1981. So how do they deal with the environmental damages? It's civil law 1.0, civil law 1.0. So we have the culpability. There are a few exceptions to the rules. We have the objective civil liability, and the rule is the guilty party. Who is the guilty party? And somebody has to prove the guilty party. So we have two cases here. Two cases on environmental damages. The first one, the disaster that we know as the Minamata disease case, which was the contamination of the waters by mercury. This happened in the south of Japan via the pollution, a very interesting biochemical process that happened. Many people and children and animals were contaminated by mercury, and they had severe developmental problems and mobility problems. Was this, did this become a lawsuit? Yes, it became a lawsuit, and they had legal analyses and many civil lawsuits. What were they trying to achieve with that? Reparation for the victims. So the main objective of the civil lawsuits was the financial compensation or compensations for these victims. And who filed the lawsuits? The victims. And they had to prove the nexus, the causes, and it was a very complex lawsuit and story, but I basically want to say there was no lawsuit that asked in terms of civil liability the recovery of those damages, the environmental damages, because this was impossible to do in Japan via civil cases or the civil lawsuit. On the other hand, we had a huge catastrophe here in Brazil. the Mariana Tailings Dam collapse that happened in the city of Mariana. And this causes damages that went through many states in Brazil. The damages represented the destruction of cities, pollution of rivers, destruction of ecosystems. All of this chain of damages can be protected by the civil code and filing a civil lawsuit, even the environmental damages that didn't impact human lives. So I don't need an individual damage here in Brazil to try to find my reparation. So the environmental damages are enough. And who were the greatest stakeholders of these lawsuits in Brazil? The public prosecutor's office. Yes, the public prosecutor's office. That's a huge difference between Brazil and Japan. Now, so I visited Japan in 2022. That was my last visit when I went there to study with Professor Kubo, environmental rights. And why am I sharing this example? Because it's a very pragmatic example and the difference between Brazil and Japan and our legal systems. So this black rabbit that you can see on the slide from the island of Amami. Amami is an island in the south of Japan, way down in the south of Japan, and they have unique species there. They say that this rabbit is ultra primitive, that it's like a living fossil. In the Kagoshima province, authorized the construction of golf courses, and these golf courses were going to damage the Amami rabbit habitat. And an attorney that I could interview, Dr. Kawahashi, he was representing the black rabbit of Amami. They were the defendants. No, they were the people who filed the lawsuit. And there was a writ of mandamus, and the rabbits were the people filing the lawsuit. I'm using inverted commas. And the judiciary branch and the man looked at that and said, no, a rabbit is not an animal that has rights, yes? I was only going to talk about the elephant Sandro. Prosecutor Miyashima is here. In Paraná, a court said that 2 dogs could file a lawsuit. But this was not a civil lawsuit, a public civil lawsuit. It was a civil lawsuit, and the names of the dogs were Rambo and Spike, joint with an NGO that was representing them, filed the lawsuit. The first chamber judge extinguished the lawsuit and said, no, they can file a lawsuit because the Brazilian legislation protects the dogs, regardless of the ecological function that they have. But the case I'm going to mention now is elephant Sandro. It's an elephant that was in a zoo in the countryside of São Paulo, living in a very inadequate place for its dimensions. Elephant Sandro came from Asia, and he never lived in his natural habitat. But via a civil lawsuit, the public prosecutor's animal, trying to think about this animal's welfare, filed the lawsuit, and now this animal, Sandro, elephant Sandro, is going to be transported to a sanctuary for elephants in the state of Mato Grosso. Just like for the black rabbit of Amami in Japan, this would be unheard of in Brazil, but we could do it to protect the animal's welfare. Having said this, I would like to share the following message. What I'm trying to say is that the environment, I'm not trying to say that is that the environmental protection in Japan is different from Brazil. And so our society in general, they can file lawsuits, the public prosecutor's office can do that, protecting the environment as an asset per se. And environmental damages do not need to mean an individual damage or a human life damage here in Brazil. So the public administration here in Brazil also plays a role. And in Japan, since we don't have the civil liability instrument in Japan, the difference is very big. And having said this, still having 2 minutes and 4 seconds to finish my presentation, I would like to thank all of you. Thank you so much, Professor Tiago Trentinella, because he shared relevant thoughts with us, and everybody can see that our main topic is trends in private law. There is a trend in Brazil, a trend in Japan, protecting these pillars, the constitutional law, the dignity of human beings, good faith, protecting the vulnerable, animals, human beings or animals, and so protection to animals. I apologize to Professor Thiago for the technical failure we had at the beginning. Thank you very much.
Oh, yes. Professor Yoshida está perguntando se a audiência tem alguma pergunta.
Are there any questions? I would like to greet Chief Justice Herman Benjamin and our Justice Ricardo Vilas Boas. He works with private law. We have already gone beyond the time allotted to us. This is the reason why the protocol department telling me that we wouldn't have time for a Q&A. But if you want to make a comment or a question to the other speakers, please feel free to do so, Professor Yoshida.
Some of the reactions to our presentation.
Thanks. Então, eu pergunto se alguém da audiência tem alguma...
So, anybody in the audience, do you have any questions, any remarks? Would you like to make a comment about any of the presentations? So, Justice?
No?
No?
They're a little shy, I think. They're shy.
Interested in my talk?
Eu acho que estão todos um pouco tímidos.
I think they're all a little bit shy and concerned with time. No, very well. Okay, then. So the participant certificates are in front of you. Please do take them with you. And I'm very happy then to close the panel on these new visions on private law. And inviting our chief here. Now, are you going to speak now, Chief Justice? Okay, well, the panel's closed, and I invite the panelists here to take a picture in front of the flags to take the panel's official picture. Thank you very much.
É com você.
Muito obrigado, senhor presidente.
Lembrando que há um cronômetro ao final. Giovana, são quantos minutos? Como? 15 minutos.
Muito obrigado, senhor presidente. Com essa introdução generosa, eu já nem vou me dar o trabalho de apresentar o tema que já foi brilhantemente apresentado pelo nosso querido presidente. Então, eu vou imediatamente passar a palavra ao nosso primeiro palestrante, que é o embaixador Philip Fox Drummond Gou. Espero que esteja correta a pronúncia do seu último nome, que é secretário de Assuntos Econômicos e Financeiros do Ministério das Relações Exteriores do Brasil, pelo tempo regulamentar aqui, que foi assinalado nas instruções de 15 minutos. Por favor, a palavra.
Muito obrigado, ministro. Ministro Herman Benjamin, ministra Nancy. Nós estamos, então, mudando um pouco o foco das discussões com relação ao que foi feito na vez passada, né? Então, agora nós estamos colocando o foco mais na parte econômica, especialmente em comércio, investimentos e cadeia de suprimentos. No caso específico de relações Brasil-Japão, nós podemos aproveitar para colocar sobre ênfase o lançamento das negociações entre os dois países há cerca de um mês, tá? Quando essas negociações estiverem concluídas, nós vamos ter certamente grande repercussão em termos de direito público e de direito privado, né? Tenho que dizer que essa é uma das diversas frentes negociadoras que nós temos. Foram abertas inúmeras discussões com países da Ásia, da Europa, da América do Norte, Oriente Médio, e a frente Japão sempre foi uma prioridade para o Brasil, o seu
Priority
lançamento.
for Brazil. We are trying to launch this for quite a few decades now, in truth. And it was now possible to finally have it take place. So we're going to have a first round of negotiations now in the second semester. And we're working so that we may have a balanced result in the several areas of interest for both countries, both on the industrial part as well as in the agricultural side of things. So this is the context of the negotiation between Brazil and Japan. But I think it is important, since we're discussing these subjects now, that we examine the context in which these negotiations are taking place. And the context is a complicated context. We are living a very severe, acute crisis of multilateralism, as you can see. Not just of economic multilateralism, but as well as the political one, among others. And as a result, we have a fragmentation of the rules, trade rules, investment rules. So we must learn to operate in a new context, a new world. And this has a huge impact in the application of law. Of course, you leave a comfortable environment where on trade you had stable rules with the WTO, and now for several different reasons, you have several kinds of rules in different places, and sometimes these rules might even contradict each other, which makes the situation even more difficult. In truth, we need, and it's one of the main conclusions of my speech here, we have an aging trade or commerce system, and you almost need to start doing a total reboot of the system in its numerous areas. So let's examine the several parts of this question in terms of diagnostics as well as in what can be done of the tendencies. Let's start with diagnostics. Firstly, diagnostics on multilateralism, the WTO, for example. So the WTO, as is well known, is in a state of practical paralysis. This paralysis is not something recent. I would say it started about 2 decades ago, when it started getting very difficult for you to reach results for the negotiations at the WTO. If it was possible to find a specific date, I would say it was July 2008, where we had a meeting in Geneva, ministerial meeting that was very long, in the Doha rounds of negotiations, where we did not reach an agreement. There onwards, it was just downhill. And we also have a crisis in the pillar of controversy solutions, of disputes. So, as you know, WTO is an organization with 2 forums, one with appeals and the others with deliberations. And so because of one country, the appeals organization or level was being defunded until it became unoperational. The judges would no longer give consensus to the designation or the naming of other people. And so the mandates of the other arbitrators ended, and we ended up not having the possibility of using the appeals of the WTO anymore. So you have a situation of paralysis in negotiations, but also in the possibility of having arbitrage for a process. So this is the scenario from the multilateral point of view. I'm then going to talk a little bit about what's actually being attempted to currently by the players. Well, so to try and deal with this paralysis, the countries are trying to intensify and accelerate the bilateral negotiations. In the case of Brazil, bilateral means Mercosul with other countries. So as I mentioned in the beginning, we have a big front of negotiations that is open, including negotiations with Japan now, but several others that I could cite here, or some that have already ended, like the one with Singapore, where we had the decree emitted with the FTA, or the EFTA one also, for some countries of EFTA, so Iceland, Norway, until the end of the year. Switzerland might take a little bit longer because they will probably have to have a referendum on this agreement. Because of the rules in Switzerland, it's relatively easy to request a referendum. 50,000 signatures are enough to start a vote. But there is great optimism in regards to this. The EU, of course, the European Union, that just started being applied on the 1st of May with the FTA, and open negotiations currently with Canada, the UAE, the UEA, Indonesia, India, Vietnam, South Korea, and as you have seen, the president of Brazil was speaking with Xi Jinping recently, and there is an interest from China as well in participating in such negotiations. So it's quite a broad range of possibilities to negotiate.
I said all of this to also provide for the paralyses of the WTO. And so we also have, if you have rules, regulations in the multilateral world and rules in the bilateral world, there is the chance, a reasonable chance, that we're going to have conflicts, okay, among these rules. And this is exactly what's happening now. I can give you one example that can be seen in all of the newspapers around the world, exactly regarding this kind of dispute or conflict with the EU, steel materials and products, okay? So you must have read, because the Europeans, starting on the 1st of July, they implemented quantitative limitations for the entire world, not only for Brazil. And they did that based upon the WTO rules. And these rules, even though they were done properly and correctly, they are shocking with what we negotiated with them in the free trade agreement. There shouldn't be any quantitative limitation between the EU and Brazil. These situations, mainly in a context in which the WTO is paralyzed, they are going to happen more and more frequently. And we have to consider this every time we have a discussion. And also, when it comes to the diagnostics, you have unilateral measures. And so in the newspapers, you can see this all the time, the unilateral decisions made by the USA. And they go alongside the margins of any rules created by the WTO, and they don't have any fundamentals or foundations in any bilateral negotiation. So you have this complex scenario, and this generates a certain amount, a large amount of uncertainties for the operators, the foreign trade operators, and also for the international trade law. So the idea is, what can we do? What can we do to minimize these risks? So what can you try to do? What can you try to do? And this is what we're trying to do, and it's a very, very hard job. When it comes to multilateral issues, if the WTO is not working, let's reform the WTO. So there is a group of countries that is, they are exercising pressure to reform the WTO. Brazil, the EU countries, Japan is also involved in this, South Korea, Australia, New Zealand, Mexico, among others. So this reform discussion is a discussion that is highly complex, because when you talk about reforming an organization, each nation has a different idea of what a reform would be. The obvious place for us to start this reform would be the conflict solution mechanism, because if it's not working, nothing else is going to work. But some countries said, no, we don't want a body that has two levels or two chambers. Regardless of what you're going to do, it doesn't matter what you're going to do. So we didn't like the appeal court from the past. We're not going to like the appeal court now in the future. So this is a complex problem. We have tried to fix it a little bit using an MPIA mechanism. The MPIA mechanism is a review of the rulings or sentences. It's plurilateral. Not all of the state members of the WTO are part of this, but those who are members, they commit themselves to respect the sentences of these judges. They are 10 judges that work with arbitration. We have had a Brazilian one, Ambassador Graça Lima, and now we have a Brazilian ambassador that is part of the list of judges that do the arbitration. But the mechanism still has a few problems. It could do way more. As we wait for that, the conflict resolution mechanism continues working. You have read in the newspaper last week, we filed a lawsuit against the USA exactly about the high tariffs. It is working, and that's interesting, but obviously the countries, they are using this mechanism very little. Just to give you an idea, we had already asked the Americans to sit down with us and give us a consultation. We had 640 processes, and the new lawsuit is only 6 lawsuits or processes were analyzed in an entire year. So this gives you an idea of the size of the problem. I don't know if he's saying processes or lawsuits. Okay, I apologize for that. So the bilaterals, if the multilateral scenario has been weakened, so the bilateral scenarios are going to become more important, right? That's the logical conclusion. And that is the basic idea behind everything. Of course, we are facing a paradox. And this paradox is the following. We can see that the entire world is becoming more and more protective in general terms, mainly the most important countries, but at the same time, they are trying to make agreements. Is this compatible, one thing with the other? Well, we may have some problems, and we are already having some problems. Maybe the solution is not going to be totally sustainable in the long term if we don't carry out a huge effort to touch this multilateralism. Only the bilateral agreements may not work. And finally, when it comes to unilateralism, what can we do? A country such as Brazil, to solve this issue. The solution was given by our National Congress last year when they passed the law. They passed a law. So now we have a decree, a law, that in certain circumstances, we have to obey certain rights, and it's possible for you to establish countermeasures, so that you can offer reparation to damages that may have been caused. So this is the scenario. It's a highly complex scenario, as you well know. The diagnostics, and this is a very simple summary, the ones that I mentioned are the ones that I mentioned, and the way we can work, there are multiple possibilities, but this challenge is very relevant, important, and something that demands a lot of my time. Thank you very much for your attention. It was a pleasure to speak in front of you today. Thank you. Thank you very much, Ambassador Philip Fox Drummond Go, for your brilliant summary of the scenario, and that you were able to mention to us about the foreign affairs, the challenges that we are facing, the challenges that Brazil and the contemporary world is facing. So I would now like to pass the floor to Professor Mari Shimizu. She is a professor at the law school at Osaka University.
Hello, thank you so much for these opportunities. I'm very honored to be participating in this seminar. And considering the time limitation, I would like to start my presentation. So today I will speak about the impact of G7 and Australia's critical minerals framework on investment in South American countries, based on my trade law expertise. So I need to make an excuse at the beginning that it is beyond my capacity to differentiate various critical minerals. So please consider that my arguments are mostly based on the situation regarding rare earths. And this way. So first, with regard to essential issues regarding investment in critical minerals, we all know about the current status where existing supplying countries like China have a dominant share in the global critical minerals market, and in some cases, weaponize that dominant position. And the background here is that the critical mineral business has a unique high risk for investment, and new products with high prices are less competitive to the dominant suppliers' products. This is due to many factors like first, considerable time and resources taken before the commencement of business operation, and second, price volatility due to the small market size compared to base metal. So the dominant suppliers can manipulate prices by adjusting the supply volume, which is sometimes called predatory pricing. And third, heavy costs for electricity and regulatory compliance, which makes the price higher. And fourth, limited public demands for critical minerals. Thus, market principles have only led to prevalence of lower price products from existing dominant suppliers. And to enhance new investment with a long-term profit prospect, a certain degree of government intervention is required. This is to show the high operating costs required for the new investment, which I borrowed from the IEA report. And next, with this background, G7 and Australia, altered by export controls over us by China, they take new progressive initiatives on critical minerals, and since 2025, which is endorsed by Australia. And the key suggestions there are, as highlighted here, first, standards-based markets to reflect the real costs of responsible business. Lists of possible standards are on labor and human rights, anti-bribery and corruption, environment, which is pollution and land degradation, as I wrote in the last part of the presentation. And second, obviously, in the second red letter, mobilizing capital and investing in partnership, which means enhancement of financing. And third, allied efforts for aggregating demand, coordinating offtake agreements, implementing price stabilization mechanisms is also noted. And most notably, which is highlighted in yellow here in the latter half, they mentioned a commitment to using the tools such as investment policies, trade measures, price floors to reduce and eventually eliminate the dependence on critical mineral supply chains dominated by non-market policies and practices. So they specifically mention about exclusion of the dominance to the Chinese products. And next, these initiatives are echoed in the United States plurilateral initiatives to negotiate trade measures to restrict imports by price floors, for example. USTR has conducted public comments on the initiative through early in this year, based on an affirmative finding in 232 investigation for processed critical minerals. The result is not published yet, but questions made by the USTR in this public comment indicate certain practical difficulties in establishing border measures with price mechanism. Examples of the question, sorry about the very small letters, but examples of the questions are like methods to calculate target or reference prices, or the important one, the extent to reflect differences in the costs of extraction, processing, and refining in various markets for reference price. And the next, in parallel, policy measures related to critical minerals in various countries have surged in recent years. And some key types of domestic measures are, first and foremost, priority analysis, identifying which minerals should be prioritized for your own country. And the second, financing, enhancement of various financing, which are subsidies in international economic law norm, through including public loans, offtake agreements that guarantee purchase volume, or price stabilization mechanism, R&D assistance, etc. And the third one, certain countries already initiated stockpiling for emergency situations and matching system that can aggregate demands and supplies. And lastly, gradually be introduced on the side of G7 and Australia is based on concern for non-market policies and practices is exclusion of certain foreign products or investment. I will call it external sheets from now on. And typical means for this purpose are possible border measures, import restrictions and tariff, etc., or the inward investment review. And while not comprehensive, I'm sorry about the small letters again, but here I did a little comparison of domestic policies between Japan, Australia, and Brazil. So Japan has existing civil use stockpiling run by JOGMEC, which actually worked effectively in urgent situation. And the similar stockpiling system has been introduced in many other countries recently. And also to enhance the risk capital provision, recently the Economic Security Promotion Act and the JBIC Act were amended to exempt the principles of JBIC finance, which were ensuring financial soundness for JBIC and for each project, for essential foreign projects under the Economic Security Promotion Act. And next, in Australia, the Critical Mineral Strategic Reserves initiated its operation from this year with tools like offtake agreements, intermediary demand and supply aggregation, stockpiling, price floors, and ceilings. And interestingly, Australia specifically prepares information toolkit, which is like general guideline for safeguarding against foreign interference in the critical minerals sector. While Australia appreciates the trade relationship with China, on investment, it takes a stricter stance. For example, in May this year, Australia government ordered 6 China-linked investors to divest from a rare earths mining company, Northern Minerals. I'm sorry, I have to come back. So in Brazil, I'm not a professional of Brazilian situations, but from the research I made, a small research, I know that National Mining Plan 2050 and National Critical and Strategic Minerals Policy were set very recently, and a new federal governance body with investment screening powers was established. And notable here is Brazil's position signaled through, for example, a recent dialogue between President Xi and President Lula, is that Brazil welcomes China's additional investment and rejects the United States' call to restrict investment in the mining sector from non-market actors. I'm sorry, I have to, think I went back too much. So here is the background of commonalities and differences among the countries. For Japan, Japan has no substantial domestic reserves, but has typical key strategic manufacturing end users as its major industries that need critical minerals as essential raw materials, meaning autos, semiconductors, nuclear power plants. So Japan needs to invest in foreign mineral-rich countries, except for China, to procure critical minerals for its end users. Japan is highly alerted on China's dominance as it has experienced economic coercion multiple times. Also, Japan has allied with the United States after World War II in the terms of economics and security. On the other hand, Australia has rich domestic reserves, but need refinement and processing capacity. But it has a lesser interests in procuring critical minerals for its domestic end users. And this industrial structure applies to Brazil as well, I believe. However, the two resource-rich countries have a slight different approach regarding their position in the United States and China conflict. So Australia is substantially alerted on China's dominance because it has already experienced price manipulation as from the competitor, China. And it is actually within a decent China's arms threat geologically. And on the other hand, it has a broad alliance with the United States on military and economic terms. But Brazil is less alerted on China's dominance. While I think there is an inherent competitive relationship even with China and Brazil, it is still at a very early stage. And it is geologically located farthest from China and not subject to security threat from China. And there is a traditional alliance relationship as BRICS. And with regard to the United States, there is a certain tension between Trump's second administration, and Brazil has been subject to a stronger coercion from the United States. So in short, while all of the three countries need capacity expansion, Japan and Australia are key constituents of G7 framework discussing external shields, but Brazil remains comparatively open. Now I would like to see some problems to address regarding representative policy measures, but for the time's sake, I would like to focus on standards and external shields here. So with regard to standards, actually there is a possible tension between relaxing procedural regulations to facilitate new investment versus setting high standards to exclude non-market policy products. And it is not easy to set non-arbitrary but effective standards that can achieve both aims. And we can recall that recent United States 301 measure based on forced labor, there is a possibility of arbitrary standard regarding the forced labor. And second, on external shields, which I mean exclusion of certain products or investment by import or export restriction, border price mechanisms, investment reviews, and sometimes by standards. And actually, with this point, as Ambassador Goff has mentioned, there is a tension with multilateral rules as well, but I'm not going to the details of the multilateral trade rules. But aside of that, with regard to border price mechanism, it is, again, also difficult to set a non-arbitrary but effective minimum price. And also price measures mean higher prices for downstream, and it may be absorbed by consumers, but it might require subsidies for most affected downstream users, like EV battery industries. And actually, the recent IEA report that I cited already pointed out that this price burden can be considered security premium. And whatever the specific manner, these external shields are eventually underlined with concerns for relying on single adversary resource, or I can rephrase it as supply chain resilience. And under the current unstable geopolitical circumstances, it is difficult to deny the validity of this concern. But this is a mixture of security and industry interests. And one of the problems is that the security aspects here tend to allow less transparency and predictability. And with this, I would like to go on to the impact, possible impact for the investment in South American countries. So first, with regard to standards, as downstream industries in other jurisdictions need to comply with the standards enforced in their own jurisdictions, if the mining and refining industries in South American countries do not comply with such standards, they may lose markets of such high standard jurisdictions and demands of large multinational corporations. As an example of the litigation risk of multilateral companies caused by the mandatory standards, we can recall Apple being sued in multiple countries, for example, United States, Belgium, and Congo, for procurement of conflict minerals in Congo. The impact of standards can be substantial as they are likely to be used as conditions for other measures like subsidies, procurement stage of stockpiling, and external shields. Without complying them, the suppliers cannot get the relevant benefits under the other measures. And second, on external shields, actually currently United States, EU, Korea, Japan, China, all of them show strong appetite for critical minerals business in Brazil. They are not likely to put the shields to their own mineral projects. So maybe not much adverse effects on mineral business in South American countries that are added to standards, meaning possibly there will be two separate supply chains for critical minerals originating from open South American countries, depending on the major source of foreign investment, whether they be from G7 group or China group, which may also mean a decent decoupling in the supply chains. Even though it will be less efficient than free trade world, being open to both groups may mean larger investment on broader downstream markets to the extent South American countries themselves remain market country and or non-adversary. But one concern I have is whether price manipulation happened in Australia would not happen in South American countries at all or not. And third, with stockpiling and aggregation of supply and/or demands, actually integration and aggregation has a benefit of economies in scale. So it is better to participate in the large group to achieve stockpiling and aggregation of supply and demand. And with regard to the prospect, the next two slides, again, I borrowed from the IEA report. For here, the gray part shows the refined output from countries other than top supplier, and red part shows refined output of a top producer. And top producer often is China. And you can see that for only rare earths, the gray part is larger than the red part. So it means that efforts to develop new sources of refined rare earths have succeeded to some extent for the last few years. And so targeted efforts for diversification may actually change the dominance in critical minerals markets. But there are substantial reservations that I mentioned here. To satisfy the growing demands, the efforts to develop alternative resources need to be significantly enhanced. And second, there will be limits for subsidies. There is no limitless financial resources. So with rare earths, G7 could succeed to some extent, but how much that effort can cover is a remaining question. And then what can be done? This is the conclusion of my presentation. So first, what can be done for developing critical minerals capacity in a constructive manner amidst the current tension? First, on standards, with its significance due to its linkage to other policy measures, harmonization in the long term would be desirable so that they can incorporate valid regulatory considerations like environmental, human rights, etc., and flexibility and fairness. And second, on external shields, I consider that they will be boiled down to the supply chain resilience and/or security concerns, which are complex and sensitive. But appropriate safeguarding means for foreign interference while accepting the investment into strategic industries may be crystallized further domestically and internationally. It may ensure a more predictable route of accepting various foreign investment with prospects of less trade barriers for the outcome products. Such efforts would contribute to prevent unpredictability and/or excessive decoupling. Third, on stockpiling and aggregation of supply and demand, coordination is highly desirable to avoid duplication and achieve economies of scale. A soft coordination framework to function in emergency situations like the IPEF's Supply Chain Crisis Response Network may be a realistic example. And these topics may be also a good candidates to be discussed in Mercosur-Japan framework as well. With this, I would like to conclude my presentation. Thank you for your patience.
Agradecer a professora Mari Schmitz pela brilhante apresentação.
I'd like to thank Mari Schmitz for the fantastic presentation on the situation in rare minerals and the policies that have been taken between Japan, Australia, and Brazil. And I'll hand over immediately to Professor Rodrigo Kanayama from the Faculty of Law of the Federal University of Paraná. Good afternoon, everyone. I would start with my self-description. I am Rodrigo Kanayama. I am of Japanese descent. Therefore, I am of Oriental descent, ethnicity. I am 170 tall. I have dark hair. I wear glasses, and I'm wearing a blue suit. And I am speaking out of the mic so that you may hear where I am in the room. So, to start this presentation, I prepared a conversation here, Justice Cueva, and I greet you here as the chair of this panel. So it's a great pleasure to be here. And in your name, I greet all those that are part of this panel. I greet the Chief Justice of this court, Herman Benjamin, Justice Nancy Andrighi. I greet also and the President of the court, Miyajima. I greet Justice Aoyama, representatives of our court, all of them here of Oriental ethnicity, and Ambassador Yonaguchi for the invitation for supporting this important event between Brazil and Japan. I've obviously always been interested in Oriental culture since I was born, but also because my grandfather, since 1942, was a lawyer in the state of Paraná. And so we've always been interested in several legal discussions, but also not just public law, but also a little bit of private law. So this kind of talk has always been part of family discussions as well. And these discussions remained. I had the satisfaction of entering the Federal University of Paraná. And I had fantastic students that also ended up studying Japanese law. One of them is Eduardo Mesquita Kobayashi. And he wished he was here. I had several discussions and even 2 articles on Japanese law. One about the 9th article of the Japanese Constitution, the Pacifist Clause, where we analyzed the history of the Japanese Constitution until we reached the recent Constitution of the Japan having security forces, and then more recently, a discussion that started in the Supreme Court of the state of Paraná on advocacy in Japan, or the law practice in Japan, dismystifying some certainties that we believed that are actually myths, that Japan does not take things to the judiciary because they are pacifist people, but that is not proven through the measures and the studies that is done, that there are institutional arrangements that take to behaviors of Japanese to be different from Brazil, which ends up meaning there are less procedures or lawsuits in Japan than in Brazil. And now I'm going to mention about these institutional arrangements. Why do we need legal norms that are trustworthy? And here, it seems to me that this is the contact point between the practice of law with academia to show that we can improve Brazilian laws and Japanese, since the lack of lawyers in Japan also causes negative effects for Japanese economy, which we can see through these academic studies. I brought here a discussion that is also part of my debates at the university but I ended up mixing a little bit of private law as well, because I'm going to deal with contracts here. So here we're talking about trade, international trade. We're talking about investments, supply chains. And so that there can be trade, I need to have contracts. But contracts do not work in a vacuum. They do not exist on their own. Contracts, trade, and investments require, obviously, rights, laws, institutions, legal norms. No contract survives without the state, and no single contract can live without a state that has legal norms that are foreseeable, and that the conduct in the states be foreseeable, safe. And there you have the idea of the principle of legal certainty. And legal certainty is not just an empty principle for law. It's economic infrastructure that is as important as the existence of ports and roads. Legal certainty is fundamental for trade between countries. As Ambassador Philip said here, they brought the idea of the possible consequence of these new international relations through multilateralism. That is the idea that each person can build their own rules between countries having bilateralism. There isn't anymore a group of norms that regulates world trade, but rather relations between countries directly. And legal certainty comes from law. Law has its role of guaranteeing this sustainability of commercial or trade relations. And so we need institutions to enable economic relations that are long-lasting. And here, this is something we also study in the university from Douglas North, that is institutionalist, that talks about the formal and informal institutions as structure, incentives, and reduce uncertainties, or as Williamson used to say, that dealt on contracts, economic transactions, that it wasn't enough to define the cost for production, but also negotiation costs, surveillance costs, for also conflict resolution costs. So the structure for conflict resolution itself also has the reduction of transaction costs in trade contracts. And contracts are by nature incomplete, as Williamson would say. It is not possible to foresee all future circumstances, what will happen in the future in long terms with the contract. That's why they are incomplete contracts. I cannot foresee all hypotheses, everything that comes from that contractual relationship. And when there's uncertainty, the bigger the uncertainty, the bigger the transaction cost. So the more complex, the more long-lasting, the longer-lasting these economic relations and trade relations are, the more we will need institutions, so legal norms that are trustworthy, efficient adaptation mechanisms, and efficient conflict resolution mechanisms. That being said, the investor, when it comes to do business in any of the two countries, does not only evaluate the existing norms, they also evaluate the possibility of these norms being altered, of being cancelled, being reinterpreted, and worse, not respected or ignored by the government. And to give certainty, it is necessary the so-called believable engagements. They must be trustworthy. They must be able to trust in them. So in both countries, we have an institutional structure that comes from the action of the legislative that creates the norms, the executive branch that regulates and applies these norms, of the judiciary branch that interprets and applies the legal rules and the control organizations that surveil or control the contracts, and the relationship between the powers must be foreseeable between the branches so that we can have legal certainty for the investor. It is impossible to imagine a legal certainty where the understanding can be altered randomly. It must be possible to give this legal certainty to the investors. This is the role of the courts in Brazil. The rule of the judiciary in Brazil is also giving us legal certainty for the investor. For example, the STJ, the National High Court, the Supreme Federal Court, the Supreme Regional Courts have this role of giving legal certainty. We recently saw the alteration that is about to be signed by the president, where they intend to avoid that the Supreme Court concern itself with questions that are already been repeated and small causes, and that does not give actually legal certainty, but rather the opposite. So the idea is to bring a uniform understanding in specific cases that can be applied to all the courts in Brazil.
So we are moving and taking right steps. And now, talking about the work that I do, because I work a lot with public budgeting at the university, I'm going to discuss another essential item for legal certainty, which is the fiscal and tax liability or responsibility. So the honesty behind the public budgeting is part of the legal scenario of the contracts. The lack of fiscal responsibility can generate the interruption of the payment of contracts, the suspension of these contracts, ad hoc amendments. I can change the taxes according to the moment. The contracts are not complied with. Public services and policies become inferior, and regulatory instability. So legal certainty also encompasses this idea of legal certainty. So we have a list of organizations that must be observed so that we can ensure a safe environment for a foreign investor to come to Brazil, for them to feel sure that there won't be any problems with their investments. And going back to the judiciary branch reduces the cost. So the judiciary branch in any country should be like that. We have to be predictable, efficient, coherent in our rulings, to be prospective, to apply the rules into the future, never for the past, preserving the contracts, and to have an enforcement mechanism that is going to allow the court to make the ruling be respected. It's not enough only to issue a ruling. Recently, me and Professor Fabrício Tomiko, we teach political sciences. We worked upon a paper that is still to be published. We made a comparison between the American judiciary branch and the Brazilian judiciary branch, comparing costs and efficiency. Even though our judiciary branch has a higher cost, we are reaching the U.S. judiciary branch in terms of productivity. So in the last 5 years, we have been improving. So we did this research 5 years ago and now again. So the Brazilian judiciary branch is reaching the productivity level of the U.S. judiciary. This is what we want. We want to have institutions that truly work properly, and ensure legal certainty to foreign investors. And we also have the bonds, the debt bonds, the precatórios that we call in Brazil, the precatory letters, and they require a specific procedure. We pay for these bonds, these debt bonds, and they join a line, and this debt is paid to them in the future. So they are court-ordered debt bonds. And so we have this in our constitution. And about the effectiveness of the rulings of the judiciary branch. So we have built something when we talk about indemnization. when we have people that the government owes. So moving on to my conclusion, I understand that the contracts we have are essential for our economy, for our economic development, and for our trade relations, the trade relations between nations. But the institutions, the national laws, they are the infrastructure of all of the safeties, legal certainty, security, and they support all of the international trade. And with this, I conclude my presentation. Thank you so much for your attention, and I'm totally at your disposal for any debates. Thank you, Professor Rodrigo, for your brilliant presentation about the situation of the judiciary branch in Brazil. I would like to pass the floor to Dr. Magali Favaretto. She is from the São Paulo Getúlio Vargas Foundation Law School, the FGV in São Paulo. Good afternoon, ladies and gentlemen. I am a researcher at the Global Legal Research Center at the law school in the FGV, and I'm part of the geoeconomy study group at the FGV, which is a part of the WTO. I'm not here to share with you a theoretical paper, as many of the colleagues have shared brilliant papers, and I'm very, very interested in Professor Mari Shimizu's paper. We are developing now a research about critical minerals and looking at this issue of how Brazil is positioning itself when it comes to the competition between the USA and China, the economic statecraft of China, and you mentioned the standards that you shared so well, the American model based upon agreements, bilateral agreements, and how Brazil has been developing its capacity that we're calling regulatory capacity. And this is a research that is still ongoing. So what I would like to share with you is way more an idea of the trade and investments as empirical fields, and it is a connection between the public and the private sectors. The first question is, why is the international economic law interesting for this panel? What are the borders between the public and the private, and the borders between the public and the private that we have discussed all day today? It becomes clearer in the international trade, and then it goes to the domestic law, public law, private law. So the topic of this event is almost literally what happens and has been happening with trade and in the international scenario in the last decades. I'm going to show a simultaneous double movement. In the international scenario, we can see this double movement. On one side, we have the publicization of the trade and the investment and the public interest and the reason for the state to exist. They are being reinserted into the market. In this movement, the economic safety and security has become a cross-sectional vector, manifesting itself in foreign investments, screening, sanctions, controls of exports, mandatory due diligences along the value chain. And on the other side, a movement that retrofreed itself, we have the privatization of the regulation. Regulatory functions, they are migrating to private stakeholders via technical norms and rules, private certifications, codes that export rules that have extraterritorial impacts, the arbitration between investors and the state as the ISDS, and also a paralyzed WTO that is sending the trade negotiations to antagonic or antagonistic arrangements and bilateralization. But I wanted to discuss a more conceptual point that it's not only saying that the public is dominant over the private, but this distinction is not organizing the field itself. Now, giving more details to Vector 1, that would be how the state is going into the contracts once again. I have certain illustrations. We have the economic safety and security as the main axis, and the example of Japan. They have the Economic Security Promotion Act that was passed in 2022 that talks about critical minerals, subsidies to promote chain resilience, screening of the essential infrastructure, and so law, industrial policy, control of exports, imports, and also national security. And we have, the screening of investments, that we have multiple examples of the public control of foreign investments. And so they submit themselves to a private decision of investing with the state's authorization. And in third place, the due diligence mechanisms that are mandatory. We have the EU and Brazil as examples. We have the CSDD and the EUDR. The Europeans impose public duties inside the supply contracts, and also the deforestation clauses, and this is going to impact Brazil a lot. And so we have public duties inside private contracts, supply contracts. In vector number 2, that would be the inverted position. The regulation is passing from the state to private agents. We have companies, certifiers, and judges who work with arbitration. They are playing the role of regulators. We have private rules and regulations. And so publicly negotiated technical standards, they govern the access to markets, contract provisions, And so this was discussed well by Professor Kobayashi in his idea of contracts along the supply chain. And so his paper was very interesting, and the arbitration between the investors and the state. I'm going to go a little faster so that I can control the time allotted to me. Within this context, what are Brazil's and Japan's positions? These countries, they have different positions, but there are certain similarities. Is there a possibility to compare? I'm going to dare to compare them, to do comparative law that was also discussed here, and more from an institutional perspective than from a normative perspective. If there are inconsistencies, please, the Japanese scholars help me. I see Japan more like a rule maker, a creator of rules, and that is moved by vulnerabilities, just like Brazil, but for different reasons. So Japan has been a rule maker, a source of economic security. The Economic Security Promotion Act is an example of that. They are controlling the exports. Japan is a critical importer of energy, food, and minerals, and so the vulnerabilities has been making it generate rules, and they have a dense network of bilateral agreements. Brazil, on the other hand, has way more been a rule taker than a rule maker, but it has been an institutional innovator. It has been a target of extraterritorial regulation, compliance rules. It is a critical supplier of minerals, agricultural products. It needs critical minerals, mainly in the processing of these critical minerals, and it's a supplier of commodities, and it faces a challenge to supply technology. mainly in the mineral sector. And we have certain examples of Brazil as an institutional innovator. So we have an arbitration model, that is the ACFI, and we also have the public-private payment system coordinated by the Central Bank of Brazil, the PIX, the way we can transfer money from one bank account to the other for free. And this is being a problem, has become a problem between the USA and Brazil. I'm going to go very briefly over this because this has already been discussed, the strategic partnership between Brazil and Japan. But I would like to emphasize something, a binding, a connection that we have, not a binding, a connection that we have based upon a soft law. We have 80 MOUs. We have had high-level dialogues. We have had private fora, and we have had dense negotiations. The protection of investments exists as an intention, but there is no bilateral investment agreement signed between Brazil and Japan. It is monitored by the dialogue of our ambassadors without a specific mechanism to solve conflicts. And in the trade sector, in 2026, we launched the negotiations. I'm not going to go deep down into this. When it comes to chains, supply chains and strategic chains, Brazil and Japan, they are based upon the economic security and safety. We have seen this in our agreements. There is a language that talks about reliable, resilient chains, critical minerals, semiconductors, APIs. And Brazil entered this scenario as a strategic partner. And so we are organizing the sector. In the past, we only organized this via contracts and prices. And in the area of energy, please correct me if I'm mistaken, but we create a regulatory framework like the pro-ethanol. But Japan has also been setting forth sustainability criteria. But I would like to talk about a regulation that works in the private sector, mainly in the coal sector. I have an idea here about the ACFI, but I can skip that. And this is only a provocation. The hybridization between the public and the private, even though we are celebrating this together today, we should be very careful as regards this. Maybe a problem that I raised from a scholarship perspective. So the connection between the public and the private is nothing new. The markets, they were always inside the government, in the state, as we learned with Polanyi. But what has changed now is the intensity, the way, the mechanisms, sometimes the instruments that can seem to be more neutral, more technical. And finally, how is this hybridization reaching the judiciary branch? I believe that everything that is born in the international economic law arrives for us as a lawsuit. And some examples are the supply contracts with public obligations, with due diligence, private standards of certification impacting the access to the markets and sometimes generating market conflicts, liability and responsibility that goes down the value chain and their limits. And another example is the interface between the arbitration report, investment report, and the national public order. And I would like to conclude with a question. Which institutional design can maintain this hybridization being and maintaining being legitimate and open? You have the armed interdependence on one side and the risk of a regulatory imperialism on the other side. And this was my contribution. Thank you very, very much.
I'd like to thank Professor Magali for her excellent presentation on this situation that we're living through, and finally hand over to our last presenter, Professor Tomohiko Kobayashi of the School of Law of the University of Otaru.
Boa tarde a todos. I'm Tomo Kobayashi, another Kobayashi, and my name Tomo means friend in Japanese. So you can call me Amigo Kobayashi, right? And well, it's a very great honor for me to be here as part of the Japan-Brazil Law Congress again, right? Because last year I talked about the importance of traditional knowledge in pursuing the sustainable development. Importance of the traditional knowledge of indigenous peoples and local communities to develop sustainable development. And this year, I'm going to talk about critical minerals again. So, and let me echo thanking the Chief Justice Herman Benjamin and Justice Boas Cueva for hosting this session. So, as you already know, we are in a big trouble. But it's not our fault for Japan and Brazil. I don't want to blame a specific country, but this is like an international trade is disrupted by wars and unilateral measures. That is one of the biggest challenges in front of us. But as you can see, well, my presentation overlaps significantly with fellow presenters of this session. So I'd like to make my presentation as short as possible to avoid repetition. And alternatively, I don't want to delay the closing of this session and today's conference because I don't want to delay the reception hosted by the Japanese embassy. Why? As you can see, well, there is a Japanese ambassador and minister sitting right in front of me. Okay, so I'm a good Japanese, so I'd like to be polite. And so, okay, well, yeah, China export restrictions, subsidy rates, and WTO dysfunction of the appeal system in the WTO, and also MPIA, and stockpiling or investment screening, and global and strategic partnership between Brazil and Japan. They are all mentioned by my fellow presenters. So let me skip this part. And my presentation has 9 slides, and I will go through all the slides for the record because this entire session, entire conference is recorded. So you can review my presentation files sometime later. So security is not only about obtaining minerals itself. Resources needs routes, logistics, transportation, and production networks, facilities that involves sufficient resilient networks, and also intellectual property rights and other know-hows or knowledge is indispensable to ensure resilient supply chains. And well, what I can add on the previous presenter's knowledge is comparison or between the Brazil and Greenland. That's why I titled my presentation From the Amazon to the Arctic. Right? Just to, well, illustrate the need to expand the perspectives. We should not limit our discussion only to Japan and Brazil or Japan and China. We need to broaden the perspective to the global scale. Right, but I skip this slide and I skip those Law of the Sea Convention and GATT legal argument. And now we are in the slide number 6. So, of course, countries tend to, build facilities within its border. So no countries want to sell out precious minerals or resources to the abroad. So creating or developing more value-adding industry is better than just selling the primary materials. I know, understandable. However, there is a WTO rules and FTA rules, and so the countries, each and individual countries, has to demonstrate justifiable reasons if they want to restrict international trade, mainly done between the private parties. And again, Brazil and Japan has a lot of systemic partnership between each other. And as Ambassador Go mentioned, the Mercosur and Japan initiated an FTA negotiation that will have tremendous repercussions in trade and investment. But let me go directly to the conclusion, right? I admire Brazil's approach and integrity and law-abiding stance, especially to make use of the WTO dispute settlement mechanism, even though everyone knows that the appeal system of the WTO is dysfunctional due to, certain states' unilateral action. So, last August, Brazil requested a consultation against the United States over their trade measures. And this year, a week ago, Brazil again requested a consultation against the United States for their unilateral trade restrictive measures. That's a very good indications or message to the rest of the world that WTO is not dead. Still, law matters. Right. So with regard to the critical minerals issues, again, law matters. It's not only about the geopolitical power plays or diplomacy. No offense to the diplomats in front of me. So, but law matters, and international law works to ensure transparency and predictability. That means we lawyers and jurists can contribute to restore and rescue security and order in the international society. That's my message in my presentation. And with regard to the relationship between the privatization of public law and publicization of private law, let me mention that the government is becoming more committed in the international trade as a consumer of like this in the second bullet So the becoming not only a shareholder or investor, but also governments tend to become a consumer of like semiconductors or strategic goods. And by doing so, to try to help their own domestic industries, right? That is kind of nexus of or example of the privatization of public law. And I'd like to discuss these issues with you after the session or over reception. Okay, so it's been a long day, and let me remind you that carbon is a mineral. And for us, carbonated drinks like beer and champagne could be a critical minerals, not only for me, but for all of us. Thank you for your attention.
Eu quero agradecer muito
I would like to thank the humorous comments by Professor Kobayashi. I wish you all a good afternoon with carbonated drinks. Why not? We've had an excellent panel here that has given us a very in-depth panorama on the legal aspects of trade, investment, and supply chains with a level of detail that we could not possibly imagine when we started earlier today, starting with the scenario that was drawn here very well by Ambassador Philip Fox Drummond-Go, followed by Professor Mari Shimizu, and then by Professor Rodrigo, by Dr. Magali, and now by Dr. Tomohiko, all with much care, gave us a panorama of several possible scenarios in this new world we live now. Well, multilateralism is ending and we're living a horrendous competition in a new world where we do not really know where we're going to end. But we certainly have to imagine several scenarios of competition that are very different from what we had lived through so far. Thank you very much. And I wish you all, I think it's tomorrow, right? We're going to have, I wish tomorrow's panel great success. Thank you.